Welcome back, everybody. Day 21 is wrapped, and the jury has the case. Case has gone to deliberations. Today, we got the jury instructions, and we got closing arguments from McLeland and Brad Rozzi. It was a close one. Got to tell you, it was not. Nobody hit a home run. Nobody hit a home run on their closings. But a lot of good points were made, and the jury is definitely going to be left with a lot to think about. Having said that, you may have heard the jury asked to be allowed to leave to conclude their deliberations for the day at about 3:20 in the afternoon. This was about 40 minutes before the time that they were estimated by the judge that she would consider releasing them. So this is a wrinkle. Hard to know what that means, but we're going to go ahead and talk about it all. I am not going to promise you that I got every single sentence in these closing arguments, but I will tell you I did my best. And I got an awful lot. I got well over 2/3 of my legal pad is all of my notes of the closing arguments. So I did get quite a bit of it, and I'm going to go ahead and give you those details. But first, let's just talk a little bit about some of our routine things we've been discussing, the line situation. When I went to bed last night, I still was not sure really what to expect because things have definitely begun to descend into chaos, into ferality, and just really wasn't confident that I was going to be able to rely on the fact of the line to guarantee a place in the courtroom. The line is really only as good as people's willingness to respect it. And there's just been some developments over the last couple of days that have really called into question whether some of the folks who have not been here on the day in, day out basis that the rest of us are not necessarily as committed to the system that we've all worked out as we are. So I really wasn't sure what to expect, and because of that, I did get to the courthouse a little bit early today. Honestly, I don't know if there's going to be a scrum. And if there's a scrum, hey, I'm a boxer. I'm used to getting position. I'm used to, throwing my weight around. It did not. We ended up maintaining a relatively civil process for the purposes of getting through security and getting into the courthouse. However, what's typically happened is that after we get into the courthouse, we will reassemble our line wherever we're directed to do so. Previous weeks, it's been up on the 3rd floor outside of the courthouse. Recently, they've wanted us to stay on the ground floor. And then they count us off the first 16 or 18 or 24, however many they're letting into the courtroom on that particular day. Today, it was 18. And we then calmly, when we're instructed to go upstairs, calmly and in an organized fashion, just take our single file line up the stairs and once again reassemble it. Well, that didn't happen today. For the very first time, when we were counted off and directed to go ahead and go upstairs, there were folks at the back of the line who kind of bum rushed the stairs. And what was quite disappointing to me was that the members of the line who bum rushed the stairs, these were media folks. This was the media that's supposed to represent the public, willing to kind of throw elbows to get us out of their way. Really didn't think that was cool at all. So because of that, I ended up being the last person to walk into the courtroom. And most of the seats now, the obvious seats in the back 2 rows, these have already been accounted for. So I'm not quite sure where I'm going to be able to sit. I have to kind of pace the courtroom a little bit to see, is there anything open? Well, it turns out that there is. There's a couple of seats that have been allocated to the public that are seated next to the Allen family and the defense team. And as it turns out, they're actually better seats than the people who rush the stairs. So there is some karma there. Sometimes the universe really is a beautiful thing. But yeah, really, really noticeable to me to see the media kind of leading a race to the bottom when it comes to the civility that we have all been very proud of being able to maintain throughout a very, very difficult and challenging set of circumstances. Those of you on the Brad Rozzi Style Watch, which I am told has been a source of great entertainment to the Rozzi family. Apparently, Mr. Rozzi in his day-to-day life is not really a style guy at all, just kind of your average blue jeans and work shirt kind of guy. But when it comes to his suit wear, I got to tell you, he's got an eye. He's got an eye. So today he was in his kind of brighter blue suit. It's in between like a royal blue and a cobalt blue. It's a dark tone, but it is a very vivid color. He wore this with a white shirt and a very light, kind of dull pink toned tie. It looked like it was a pink tie that may have had a small detail pattern in it, which is a very common theme that he has in his ties. It's got a base color and then an almost imperceptible pattern that if you're up close, you can pick it out, but from a distance, it just serves to kind of give a different cast to the color. And so this looked like it may have been something like that with like a gold or a brass kind of very tiny detail that you can't see from the distance, but it gives it just a little bit of a glow. It turns it from more of a pink into, I don't even know what you would call that color. It's like in between pink and brown. It's almost like a taupe, but with a bit of a pink cast to it. A very very unique color as he often gives us. We did see the entire Allen family was there in the courtroom for the closing argument. So daughter Brittany, who has been avoiding this trial for the most part, other than when she testified, she was there present for the closing today. Rick's parents were there for the closing. Obviously, lots and lots of members of the victims' families present as well. Before court came into session, the judge warned us all, we need to stay quiet, thanked us for being so good, such quiet little mouses yesterday, and that we needed to keep it up, because if we're talking or whispering, there are officers in the back who won't hesitate to ask us to leave if we can't stay quiet. And she emphasized that jurors need to focus on the attorneys and not be distracted by noise from the audience. I do understand that. So we have been reminded a lot over the last few days by bailiffs, by the judge now. So we will all very quiet little mouses. I have not seen anybody brought out of the courtroom in violation of the order. When the jury was brought back in, it was about 9:15. Got a little bit of a late start today, but not too bad. It's actually, I take that back. It was probably more like about between 5 and 10 after 9, because they'd had contact with their families and access to their devices. They were asked the same questions about not researching, not having contact with anybody, not discussing the case with anybody, and so forth. And the jury indicated they were continuing to abide by those orders. By the way, guys, real quickly, I'm going to mention this again later, but I'm going to do things a little bit differently tonight. I'm going to do something I've never done before. And that's because we did get off a little bit late last night, but then I could not sleep. I slept terrible. my mind is just absolutely racing with the details of this case. It's not even my case, right? It's not even my case. But it just really was disruptive to my sleep. So I had a very, very poor night's sleep last night. I was really dragging today, and I really need to make that up tonight. So I'm going to do something I've never done before. I'm going to turn off super chats at 10 p.m. And that's just going to give me time to be able to work through what we have and still be able to wrap up in enough time that I can get a good night's sleep. If the super chats are there, I will feel obligated to look at them. I will feel a responsibility to look at them and respond to them, because I take it very seriously that, people are spending their hard-earned money, to bring their comment to my attention. And so I do want to honor that. But my husband is concerned for my health, and I do need to put some limits on it at some point. So this has been a lot of accumulation of a lot of wear. So I'm going to be doing that tonight. I'm going to be cutting off super chats at 10 p.m. So thank you to all of you. If you want to send one in, just be aware there will be a deadline. We started with the jury instructions, the way that the judge had described the process yesterday. So she read some of the initial instructions that were case specific, and then the arguments were given, and then the more general instructions were provided. So we were informed that a copy of the court's instructions was provided to the jury. They had their own copies that they would be able to go through and read along. And so the first case-specific instructions were about the first dozen pages or so of the instructions. It did not take her very long to get through them. She instructed the jury that the judge, the state, because they have the burden of proof, they get to go first, they get to go last. This is something that we talked about last night as far as having the rebuttal. And so she said after that, then the balance of the instructions would be given, and we would take a break when the state finishes, again when the defense finishes, and then again at the conclusion of the state's rebuttal. That ended up not happening because the rebuttal was very short. So the instructions, I didn't write them down, all of the words, but I just got the basic details, and they do appear to be very run-of-the-mill pattern instructions. Nothing particularly surprising in there. Some language that is, from a defense standpoint, very, very good language. They have a very robust definition of reasonable doubt and explanation of what it means to be convinced beyond a reasonable doubt. So I'll just give you some of the highlights of those. First off, one of the first things the jury is told, you are the judges of both the law and the facts. This is that issue that, wow, this is very interesting. The jury gets to decide what the law is. This is a foreign concept to me. I understand it derives from the Indiana Constitution that specifically provides for that the jury is the ultimate decider of the law and the facts. Where I'm from, jury is told, you got nothing to do with the law. You got to take the law the way the judge gives it to you, and you just apply the facts to that law. So quite a different framework. It's there's follow-up instructions that seem to make it clear that doesn't mean that they're trying to invite nullification. So they specifically are instructed that this does not mean they get to ignore, disregard, or revise the law as it exists, and that the court's instructions are the best guide as to the law. But it does mean that nobody really has the authority to tell the jury what the law means. And so they are in a position to be able to sort that out for themselves. We walked through the specific charges, 2 counts of felony murder, 2 counts of intentional murder, what the elements of each of those are. Murder in the felony murder required proof that Richard Allen 2 killed 3, either Abby or Libby, and 4 while attempting to kidnap them. They use this language in the to convict. That's another thing I'm like, wow, I've never heard this before. That if the state has failed to prove these elements beyond a reasonable doubt, they must acquit him. So they have a duty. They must vote not guilty if there's not proof beyond a reasonable doubt. But if it is proven beyond a reasonable doubt, they may convict him. They're not required to. They may, if there's proof beyond a reasonable doubt. This is just another one of those issues that it's, to my ear as an outsider to this particular legal system in this state, that does really, really sit on the edge of jury nullification. If you don't know what I mean when I'm using this term jury nullification, it's just basically the idea that the jury doesn't have to follow the law. They have the power to do whatever they think is just in any particular case. In my state, jury nullification is considered illegal. It would be considered unethical for me to suggest that the jury should ignore the law, because we have this different framework where the law comes from the judge and jury is not to concern itself with the details of what the law is. Very different framework here in Indiana. So it just is, it's quite remarkable to me. They define kidnapping as knowing or intentionally removing a person by force or threat of force from one place to another. So that's really all kidnapping means. It can be a matter of a step or two. If it's accomplished by force and you've required them to move, that is kidnapping. I guess every state is going to have slightly different definitions of very similar crimes. In Washington, it would not require any movement of the person. It could just be use of force to restrict somebody's freedom of movement. And so, we're lawyers. We think about these little details and things like that. So I hear this definition and I think to myself, is there a crime then for, like essentially holding somebody hostage? You don't make them move, but by threat of force, you don't let them leave. I'm sure there is. But that would be considered kidnapping in Washington, and it doesn't fall under the kidnapping statute here. So I assume there's some other statute for that. Obviously doesn't apply to this particular case, but just one of those things that when you think like a lawyer comes across your mind. Then intentional murder, same essential elements, just Richard Allen knowingly or intentionally killed Abby or Libby. Intent is acting with a conscious objective to do so. Knowledge is acting while aware of a high probability that the person is doing so. Knowingly act is a little bit of a abstract concept, just because I think most of us think when we're acting, we're aware of what we're doing. When are you not? Well, it's when you're like unconscious, when you're asleep. If you're involuntary, you get your knee hit with the hammer and it's not something you're trying to do. But in that circumstance, it might fit the knowing. It might fit the knowing because you're aware that your leg is moving. I guess that would just present a different set of circumstances as far as not being voluntary conduct. So largely, it's just a distinction between focused activity and activity that you are alert and engaged in, but somewhat less than purposefully driven activity. I have a hard time conceiving how this would work in a murder case. It seems to me that just for all practical purposes, it would be intentional. I mean, it's just hard to imagine a situation where a person would do an act that is bringing about somebody's death, and they're aware that they're doing it, but they don't intend to, and that be in a way that's criminal. There's an underlying idea from the common law. There's this concept of a thing called actus reus, and it's the thing in itself, the act in itself, and it's just the idea that there needs to be some type of criminal motivation for the conduct for it to be sanctioned as a crime. And so, yes, you don't punish people criminally for involuntary acts, for things that they don't have any control over. That's not somebody being it's just not somebody being malicious. It's not somebody acting with the type of mindset that is really in a position to be corrected or punished or rehabilitated or whatever by the criminal justice system. So there's just some kind of complex overlay in these concepts to me as an attorney listening to that. As a practical matter, I don't think knowingly killing really matters in this particular case. It comes down to whether Rick Allen intentionally killed him or did not. An instruction is given distinguishing between direct and circumstantial evidence. So direct evidence is when the evidence leads you to the conclusion without the requirement of drawing any inference. Circumstantial evidence is evidence that requires you to draw an inference to reach a conclusion. And both of these are acceptable evidence in courts. There is an instruction that if the defendant is going to be convicted only on circumstantial evidence, which is the case here, we don't have an eyewitness, we don't have a video camera, we don't have direct proof of what happened. We're having to infer it from the circumstances that surround that day, surround the crime scene, surround the evidence recovered, and so forth. So this is a totally circumstantial case. This instruction says if the defendant is going to be convicted solely on the basis of circumstantial evidence, the jury must be so certain of his guilt as to exclude every alternative explanation. Every alternative explanation. So this is language that struck me as a little bit stronger than the language that we get when we come to the just beyond a reasonable doubt kind of standard, where you need to be pretty sure, but you don't have to be absolutely sure. There's very few things in life that we can be 100% completely sure about. And so that's not the standard in the criminal case. We did hear an instruction that a person charged is a competent witness, but cannot be compelled to do so. And so the defendant has the right not to. And the fact that he has chosen not to testify cannot be mentioned in deliberations. There can be no basically adverse inference drawn from his decision not to do so. They can't speculate about why. They can't let it enter their deliberations. So this was the conclusion of the initial preliminary instructions. The floor was given to Mr. McLeland, and he started his argument right around 9:15 or so, maybe a little bit after. His argument lasted about an hour. Neither of the attorneys used their full allotment of time. Frankly, I think that was a smart move. It's just it's a long time to keep the jury's focus, and it's not that you couldn't structure an argument to be compelling and logical and easy to follow for a full 2.5 hours. But it's a lot of work. It's a lot of work. And it would take some talent to be able to do that. So Mr. McLeland used a PowerPoint presentation that he prepared to show his argument as he went along, to display certain items of the evidence as he went through his argument. Mr. McLeland was back to his loud, confident, almost newscasterish voice. He has a projection that is very assertive in court. And so over the last couple days of the trial, there had been moments where we'd seen that kind of fade out a little bit, seem perhaps a little unsure, a little uncertain. But he did have his full projection back. I've made comments before as well about Mr. McLeland's style. We don't do the full style watch for him, but he also has a rather unique sense of style with his dress. He tends to like contrasting colors and patterns, things that are potentially bordering on a little garish. Sometimes, it works very well. Sometimes it's a little, I don't know about that. So like just bright colored suits with like plaid shirts and things kind of like that. But that was not his style today. Today, he was very conservative, very monochromatic, gray suit, white shirt, black tie. And I thought that was a smart choice, honestly. You don't make yourself the center of attention. Honestly, the argument isn't about you. You are the conduit You should just be letting the argument flow. The argument is the focus. And so there's no reason to wear something that's kind of going to get the jury, maybe like eyeballing that, trying to pay attention. What is that? Instead of paying close attention to the words that are coming out of your mouth. February 13th, 2017 was a day this community will never forget. It's the day that Abigail Williams and Liberty German went to the trails and never returned. And it was the day that they were murdered by Richard Allen. I told you 3 weeks ago we'd give you evidence to convict Richard Allen, and I submit that we have done just that. So let's review the evidence. I mentioned in some of my commentary that this is one of the ways I really like to structure a closing argument. I like to refer back to the opening. Remember what I told you I was going to tell you, and remember what they told you? They told you the evidence was going to show you these things and it was going to lead you to these conclusions. And here at the end of the trial, I'm here to show you why you should trust me. Because I've been consistent. I have followed up on my commitments to you, the jury, that I made in opening. And my opponent over here has not done so. It can be a very effective way to structure a closing argument. The problem, though, is I don't think it works so well when you're just using it in general terms. It's not really effective. The point of it is to be able to get into those specifics. In my opening statement, I told you that the evidence was going to show that Richard Allen was Bridge Guy. And here's how I've done that throughout the course of this trial. In my opening statement, I told you that the evidence was going to show that only one person was involved in the commission of this crime. Things like that. Just things like that. Walk them through those key points of your case, the fact that you committed to it earlier, and now how you've been able to follow that out. So there was kind of a general adoption of this principle. Remember my opening, but not drilling down into the specifics. Just kind of a general. I told you generally in opening the evidence was going to be on my side, and it's worked. So I didn't find that it didn't weigh really one way or the other as far as its persuasive content. It was just sort of a thing that was said. The night before, Abigail Williams had spent the night with Liberty German, and that morning they were hanging around, they were playing with Libby's new puppy, and they decided to go to the trail. Libby's last words to her grandmother, "Grandma, it'll be okay." On the way there, they were on Snapchat. They were posting pictures, and Kelsey dropped them off at 1:48 p.m. At around 3 p.m., Derek German arrives to pick them up, but he can't find them. So he goes to walk the trail, calls several times, but they are nowhere to be found. At about 3:30, he calls Becky to report that the girls are missing. And at this point, the family swings into action. They contact Abby's mother, Anna, but nobody is able to find them. Sometime after 5 p.m., the family calls law enforcement to report that the girls are missing. Officer Catron, Deputy Catron, goes down to County Road 325, which is at the south side of the bridge, and he looks around, sees nothing, follows the driveway down to the end to Brad Weber's house, and he speaks to Brad Weber. Brad Weber says, "Sure, go ahead and have a look around my property." And he does, and he finds nothing. The search grows with family, law enforcement, members of the community coming to the area, and they search until about 2 in the morning, about 2 a.m. But they told you nobody at that time is looking for 2 dead bodies. Nobody has expected that something horrible has happened. They're just looking for the girls. But that isn't what happens here. The search resumes the next morning until noon, at which time an officer notified the command that the bodies had been found. Searchers along the creek also found the clothes in the creek, including a shoe, a tie-dyed shirt. Deputy Giancola walked to where the bodies were, and he secured the scene. He didn't get close, but he observed that both were dead and had their throats cut. You also heard that the law enforcement officers who were on the scene that day carried 9mm caliber firearms, not .40 caliber. Word went out, and CSI, crime scene investigators, arrived to process the scene. They documented, photographed, collected evidence. Showed us the photos again. These photos are hard to see. Hard to see, he tells us. But he shows them again, and these ones are not the same as far as the eyes being blacked out. So they first display the overhead view of the crime scene, both of the girls' bodies in the configuration as it shows up in the diagram. They collected the phone from underneath the shoe under Abby's body. The phone was covered in leaves, water, and dirt. They also collected a bullet that was found beneath the girls' bodies, inches from the girls' bodies. Libby's phone was immediately processed and extracted. Data was extracted, and on it they found the final video, the last thing on the camera roll. They then played the video. This video was taken at 2:13 p.m. on 2/13/17, and it shows the moment that they were kidnapped and forced down the hill by the guy in the video. That guy is Bridge Guy, and that we know that this is the moment of the kidnapping because we can hear the fear in their voices. Bridge Guy forced them down the hill with a gun to make them use a gun to force them to comply with his orders. And he says, the man says, guys, and you can hear the sound of a gun being racked down the hill. And he says, you also hear Libby saying, that be a gun. I still haven't heard these things, honestly, even on the enhanced video. I haven't heard them. The bullet found at the scene is a .40 caliber bullet. So that's also proof that a gun was used here to accomplish the control over the girls. Law enforcement enhances this video, but first they take screenshots of Bridge Guy. And in the first frame of the video, you don't see him, but in the second one, you do. Something in Libby told her that she needed to record this. She got an uncanny feeling, an uncomfortable feeling, seeing Abby be followed. They then played the enhanced video. And according to Mr. McLeland, it gives a better image of what Libby recorded. And it shows Abby being followed by Bridge Guy, shows fear in her voice and fear on her face. Law enforcement then interviewed the people on the trail that day. They spoke with Rayleigh Voorhees and Bree Wilbur. Those girls, Bree took a picture at Freedom Bridge at 12:35 p.m., got to the Monon High Bridge at about 12:45 before walking back, and then took a picture at the bench at about 1:26. After that, they see a man on the trail, and they both see the same man. They describe him as creepy, looking dangerous, and that he didn't respond or make eye contact. Doesn't mention the physical description that they gave. Then there's Betsy Blair, who had her Fitbit on. She noticed a man on the first platform of the bridge. She was on the trail between 1:45 and 2:15, and she got to the Monon High Bridge around 2 o'clock from the Mears entrance. The man she saw appeared to be watching for someone. And then she passed Abby and Libby on the trail on the way back to the Mears entrance. Sarah Carbaugh then sees a man who is muddy and bloody walking down the road at about 4 p.m. Now, all of these witnesses gave a little different description. They gave pretty different descriptions. But all were adamant that it was Bridge Guy, and they had no doubt in their minds that Bridge Guy was the person that they saw. Next, Steve Mullen was able to recover the Hoosier Harvest Store video. And on that video, he was able to identify cars that confirmed the times of the witnesses at the trail. So the video showed Kelsey's car in the vicinity of the Mears entrance about 1:49 p.m., Betsy Blair's car at 1:46 p.m., and then leaving at 2:18 p.m. Sarah Carbaugh then is shown at 3:46 p.m. And so that video confirms the times that the witnesses testified to. So this is the basis for the state's timeline. The phone is then further examined. It's extracted and analyzed by Trooper Cecil, he's First Sergeant Christopher Cecil. From it, they were able to obtain a wealth of information, including health data, Snapchat data, location data, video data. From it, they were able to determine that Abby and Libby got to the trail around 1:48 p.m. Every time that Libby logs onto Snapchat, it gets a GPS location. And so that enables them to track the girls down the trail. And the health data from the phone confirms the movements. The GPS video location of the video shows it was taken at the Monon High Bridge. And so investigators are able to map Libby's and Abby's location to the end of the Monon High Bridge. The phone registers movement until 2:32 p.m. And at that point, the phone stops moving. There's no more health data that is returned. He then walks us through the timeline up to now. He has a map up on the screen of the larger area, the road, the entrance, the trail, the bridge, and so forth. And he uses that to draw the arrows and the initials and direction of the people in the timeline. So at 12:25, Bree and Rayleigh are at the Freedom Bridge. They are walking towards the Monon High Bridge. 12:43, Bree arrives at the Monon High Bridge and takes a time-stamped photograph. At 1:26 p.m., Bree takes a picture on the bench. Thereafter, they run into Bridge Guy. At 1:46, Betsy Blair passes the Hoosier Harvest Store and begins her walk to the bridge. She gets there and then heads back towards the Mears entrance. At 1:48, Kelsey's car is headed westbound from the Mears entrance. At 2 o'clock, Betsy Blair reaches the Monon High Bridge, sees a man on the platform, and then heads back to Mears and passes Abby and Libby. Abby and Libby proceed onto the bridge. At 2:13, the video begins. At 2:32, the phone stops moving. And at 3:56, Sarah Carbaugh is traveling past the Hoosier Harvest Store and sees the muddy, bloody guy walking down the road. At this point, I noticed I stopped to take a little moment to watch the jury to just try to see how this is registering, how are they taking this in. And so one thing, the only thing that I noticed from the jury, and this was consistent with both the state and the defense, they took very few notes during the closing arguments. In previous days, especially when we were watching the videos of of Rick's conditions in Westville, when the jurors were very attentive, and we of course had nothing to do but watch the jurors, pretty much all of them, with just a couple exceptions, they were taking notes, and they were taking lots of notes. Today, that wasn't the case. There were really only a few that were taking notes, and it was much more periodic. So it does suggest to me that perhaps the jury kind of already knows what matters to them. They don't necessarily need to hear more from the lawyers. They've heard enough just by hearing the evidence, and possibly by having that opportunity to have those discussions before they go into deliberations about what it is that they've seen. So I particularly noticed that with the timeline, just because this was very specific. And so it's normally the type of thing that, I would be hoping as a lawyer, if I'm going through my closing and I'm, drawing them a picture and things like that, that they're paying very close attention and taking notes. I want to see them engaged like that. And I really didn't. I saw 4 jurors taking occasional notes during this part of the closing. Now, in fairness, I cannot see all of the jurors very well, very clearly, just because of the orientation. But it just did seem quite markedly different than it has been during the evidence stage of the trial. Following the timeline, we know that it's Bridge Guy who kidnapped them, and that after that, they're dead. The girls are dead. So if we can ID Bridge Guy, we can ID the killer. And he is guilty of felony murder. Fast forward to 2022. It's a lot of skipping over, but we fast forward to 2022 when Kathy Shank finds a tip form, an old lead sheet from Dan Doolin, and it strikes her because she doesn't remember having seen it before. The lead sheet contained a report about a man being on the trail between 1:30 and 3:30. And that he had run into girls on the trail, and that those girls were Bree Wilbur and Rayleigh Voorhees. She took the tip to Liggett, to then Sheriff Liggett, or now Sheriff Liggett, then Deputy Liggett. He knew that the girls had seen Bridge Guy, and so he got with Steve Mullen to follow up on this tip, because this was a connection between a man on the bridge and Bridge Guy. They ID'd the man who had been on the trail as Richard Allen. So they started trying to verify the information in the tip. They looked at Doolin's report. They went and got a DMV photo of Mr. Allen. They investigated his car, and his was the only 2016 black Ford Focus SE registered in Carroll County. Thanks to your questions, we learned that. It was a good nod to the jury, but still kind of overstates, a lot of this, as you'll see. This is Mr. McLeland's storytelling. He's telling a story. It's a story he wants the jury to believe, and it sounds like a compelling story if you didn't know what the evidence was. So I'm gonna save my feedback kind of and critiques of these closings until I get to the end of them. But I just occasionally can't help calling those things out that stand out, because they just, as I'm sitting there in the courtroom, it makes me uncomfortable. I know that that's overstating. The jury knows that's overstating. Makes it a little hard to trust your story. So Steve Mullen goes to Richard Allen's home, sees a matching car there, a car that matches what's on the Hoosier Harvest Store video. And then also go to the CVS where he works and sees the car there. When he compares it to the Hoosier Harvest Store video, what he sees is a light that comes through the wheels, and he's able to match that to Richard Allen's vehicle. The time of that vehicle on the Hoosier Harvest Store video is 2:27 p.m. and 1:27 p.m. And that matches what Richard Allen told David Doolin back in 2017. You got to see the entire interview with Richard Allen, in that he confirms he was wearing the same clothes as Bridge Guy. a blue or black Carhartt jacket, jeans, and boots. Is that what he said? Are you sure about that? He said he went out on the first platform on the bridge, exactly what Betsy Blair reports, and that he saw nobody but the three girls. In his interview, he changed his time from 1:30 to 3:30 to 12:30 to 1:30. And he becomes more aggressive and hostile as the interview continues. He becomes angry, and he refuses to let them search his phone, his home, his car. He makes his comment that if the photo is from the girl's phone, it's not me. So based on this interview and the information that they had obtained, investigators obtained a warrant to search his home. And at Mr. Allen's home, they found a 2016 Ford Focus that you could see the light through the rims, through the wheels. They found a large number of knives, box cutters, a blue Carhartt jacket, and a .40 caliber bullet and a hope box, as well as a .40 caliber Sig Sauer firearm, the same caliber as the bullet at the scene. This was the Bridge Guy starter kit that they recovered from Richard Allen's home. At this time, Richard Allen had other .40 caliber ammo, but it was not Winchester, it was Blazer ammo. The only Smith & Wesson Winchester .40 caliber ammunition was in the hope box. They also found pictures of Richard Allen out at the Monon High Bridge. He visited it with his family. He was clearly familiar with the area. They searched his devices that they seized, and the 2017 phone was missing. We know this because David Doolin took down the ID number for that phone, and none of the ones that were recovered match. But they were able to recover Google searches, including on April 17th of 2022, Delphi, Indiana News, and then 4 times Should I Die Now at about 10:47 p.m. Melissa Oberg then testified that that bullet was cycled through Richard Allen's .40 caliber Sig Sauer. That marks from the extractor, ejector, and chamber face all matched Richard Allen's gun. She examined other guns and could not find that the bullet was cycled through those guns. Interesting twist there. And those results were verified by her boss, who is the former president at AFTI. She also testified she's never been wrong in her career. I was taking something from the defense opening and trying to turn it to the state's advantage because that's either credible or not credible. If you find it credible, it's very persuasive. But if you find it not credible, maybe undercuts her conclusions a bit. So you see how the evidence is starting to fall into place. Richard Allen is on the trails at the same time. His bullet is at the crime scene. So they set up another interview on October the 26th. In this interview, Mr. Allen tells investigators he never loaned his gun, never loaned his car, never loaned out his clothes. Claimed he's never been mushroom hunting in the area where the girls were found. And he has no explanation for how his bullet got there. It came, but we know it came from him racking his gun to intimidate the girls before killing them and to force them to do what he wanted them to do. During this interview, he got angrier and angrier. You saw his interaction with his wife and how he tried to manipulate her and convince her he didn't do it. But the evidence confirmed that he was Bridge Guy, that he ordered them down the hill, and that he lost the bullet at the crime scene. So Mr. Allen was arrested. And after being arrested, he was moved to the Department of Corrections to keep him safe from himself and others. And ultimately, he was sent to Westville. And that could have been all. That could have been all we had in this case. But while at Westville, he starts to confess. On April 2nd, 2023, he makes a phone call to his mom, where he tells her he's given himself over to Jesus, and he wants to make sure his mom tells his wife, Kathy. The next day, he makes a call to Kathy, where he tells her, I did it. I killed Abby and Libby. He then plays this call. While the call is playing, I kind of look around the room a little bit again to take things in. I see that Judge Gold is watching the jury very closely. She's got what I would characterize as a scowl on her face, but honestly, her resting face is not real friendly and upbeat. But it's strikes me as a scowl. Some of the jurors are looking in the audience, and one of the jurors is sitting there with his eyes closed. The phone call starts off pleasant. Rick says, I wanted to apologize to you. I did it. Kathy says, no, you didn't. He says, I don't know why. She says, no, you didn't, dear. She's being very calming. They've messed up your meds or something. Why would you say something like that? Rick says, because maybe I did. I think I did. She says, they're screwing with you there, messing with your mind. He asked, did Dad tell you I called? What did I say to him? She says, they're worried because they are concerned that something is not right. Rick says again, I think I did. And she says, why say that? And he says, because I think I did. I wish I could, something I couldn't quite hear. I think it's I wish I could remember, but I don't know. Then he says, I wish they would kill me or let me apologize to the families. And Kathy says, let's not talk anymore, okay? Kathy has now gotten upset. See one of the jurors rubbing his head while that part of the conversation is taking place. I don't understand the state's strategy in a lot of respects with a lot of the choices they've made about what to highlight and what not to highlight. Because of all the calls, this is the one that really highlights all of those characteristics that Dr. Gracian testified about with respect to false memories. The way that they originate in a belief, not in a sensory experience, and that as you go over and over and over in your mind, you begin to create something that wasn't there. And so this conversation with Kathy, it really highlights that. I think I did, maybe I did. I wish I would, wish I would remember, but I don't know. This is somebody who is starting with an idea that maybe he did it and working up to it. It's completely consistent with what Dr. Gracian talked about. So I just don't understand the strategy to play this call, especially given how recently we just heard that testimony from him. Mr. McLeland continues, that phone call to his wife was unprovoked, it was unpressured, and it was of his own free will. But after that, he continues to confess. He writes a letter to the warden. It says, I'm ready to confess. I hope I can tell the families I'm sorry. On April 5th, he met with Dr. Walla, told her I killed Abby and Libby, and I'm sorry. He cried. He said he did it on his own and that he made sure that they were dead because he didn't want them to suffer. And he didn't know why he did it, but he knew that his intentions were sexual. He said he was not sure if he had sex with them. If he did, he didn't remember. And that he was a coward. He'd always been a coward his entire life. And the reason why he took their lives was to save his own. According to the witnesses, his behavior shift at this time was purposeful, and he was not psychotic when he made this confession. These confessions continue to be repeated on the door sheets. April 7th, April 8th, April 9th, he says, I killed Abby and Libby. I hope I burn in hell. April 22nd, I killed Abby and Libby. April 23rd, I killed Abby and Libby. My wife was not involved. April 26th, I killed Abby and Libby. April 29th, I killed them in Delphi using a box cutter that he left in the trash, abandoned in the trash at the CVS. He planned to rape them, but got scared and panicked and killed them instead. Then on May 3rd, he met with Dr. Walla and gave a more detailed confession. So he basically relates once again the details of the detailed confession. He shows the notes on the screen, and this is interesting because this is the first time we in the audience have been able to see how exactly Dr. Walla has kind of captured this confession. And it is written in a narrative form, and there are portions of it that are in quotes, but certainly not the entire thing. And so there's quotes, for example, I think that's where the bullet fell out. He thought the girls were older. He saw the van. It scared them. So he forced them across the creeks, cut their necks, covered their bodies with the branches. And then he left, avoiding the trail to avoid being seen, and went home and continued about his life for the next 5 years. He still continues to confess after this on May the 10th. I need you to know I did this. On May 17th, he makes a call to his mother where he says, I was worried you wouldn't love me because I said I did it. And I wouldn't tell you I did it if I didn't do it. So they played this call again. And this is the one where I remember Rick's voice being very glum the whole time. His mom is trying to be upbeat. How are you? I'm all right, I guess. Did Kathy tell you that I did it? And she says, we're not going to discuss this, okay? And it's quiet. Are you still here? Yeah, I'm still here. We love you. Regardless, yes. You know, if Kathy's okay, she's okay. We're holding each other up. I'm just worried you aren't going to love me because of the fact I said I did it. She says, Ricky, I know you're not in a good place now, and we'll always love you no matter what. But just saying it doesn't mean you did it. Well, it does when I did. Mom says, they're just messing with you. No, Mom, they're not. She says, I love you. I know you don't have it in you to do something like that. Mom, there's a long pause. I wouldn't sit here and tell you I did it if I didn't. Well, if they're messing with your meds and all that, yeah, you would. So if I did do it, you guys won't love me anymore? Remember what Dr. Wallace said? About the statements being made instead of a story in conjunction with the delusional themes. These are among his themes. He's not going to be loved. I will always love you no matter what. Okay, he says. And there's nothing you could do to make me stop loving you. Well, that's good to know. She asks if he's gotten her letters. He says, I'm not getting mail anymore. She says, I write you every day. Oh, great. Well, that's something else I can share with my therapist. Oh, you're able to see her again? Are you seeing her every week? Oh, she's coming to see me every day. Okay, all right, I'll let you go. Tell everyone else I love them. And then you hear the click, and at the end, you hear him say, okay. It's interesting. This was something that folks had caught before that I had not caught the first time. This okay at the end of the call after the phone has clicked and disconnected. This call, unprovoked, made of his own free will while he is not suffering psychosis, and he trusts Dr. Walla. He continues to confess on May 18th, June 5th, June 18th, and June 21st, and again on February 4th of 2024 at Wabash. He says, "I'm sorry for killing the girls." Trooper Harshman is listening and watching. He's listening to all these phone calls, watching all of the videos. He hears these confessions. He reads Dr. Walla's reports and with those confessions and the details. And he notices a detail that he didn't know before. That Richard Allen reported being scared by seeing a van. And that's a detail only the killer would know. So they followed up and thought maybe he saw the van on 625 where it leads to the Weber home. So they did research, looked into the DMV records and found Brad Weber owned a van in February of 2017. So investigator Mullen and Harshman called Brad Weber in for an interview. They saw in a February 17th of 2017 interview, he said he clocked out at 2:02 and got home around 2:30. And Brad Weber testified twice that he left at 2:02 and got home around 2:30, that he was driving his van that day. The route he had taken was down his driveway, and it would have taken him there at the exact time that Richard Allen would have been there. That's the van he saw. It's something only the killer would know, and Richard Allen confessed it to Dr. Walla. From all of the hours of listening to the phone calls, Harshman got a feel for Richard Allen's voice and noticed that his demeanor was the same during his confessions as other mundane things that he said. He watched the video from Libby's phone, and he has no doubt the voice in that video is Richard Allen's. Richard Allen is Bridge Guy. That's all the pieces. So now let's talk about the elements. And he walks them through the overview of the charges. Richard Allen is Bridge Guy. He used the gun to force them down the hill. He kidnapped and then murdered them. Count 3, knowingly and intentionally killed Abigail Williams. He slit her throat, made sure she was dead, and he left behind his calling card, a bullet from his gun. Count 4 is the same thing, but involving Liberty German. February 13th, 2017, the day started like any other day when Liberty German decided to go to the trail with her best friend, Abigail Williams. But Bridge Guy stole their youth and their life from them. We've shown you Richard Allen was Bridge Guy, that he ran into Rayleigh and Bree, where he was grumpy and creepy, and he went out to the platform where Betsy Blair saw him. Richard Allen lies in wait for Abby and Libby. As Libby gets to the end of the bridge, she looks back and sees Richard Allen following Abby. Something tells Libby to film. He racks his gun. Nobody else on the trail matches the description of Bridge Guy. Harshman says the voice is Richard Allen's. He forces them down the hill, and there's a 7-minute pause in the health activity. This is when he begins to have his way with them. But before he can finish, he sees the van. It's Brad Weber coming home, and it scares him. So he forces them down the creek and across the creek to a secluded spot where he cuts their necks. Libby is naked. Abby is naked at one point, but she's then partially dressed in Libby's clothes. He racks the gun again, and then it happens. He cuts Libby's throat, and she bleeds. She clutches it. She cries, and there's blood everywhere. It's a very dramatic, emotional type of telling. He then turns to Abby, cuts her throat, and she dies slowly. Then Sarah Carbaugh saw him, muddy and bloody. But he left behind the cartridge and Libby's cell phone, and those both pointed to him. Finally, then we have his confessions over and over. I killed Abby and Libby. And he tells you why he did it. He tells you details only the killer would know. I believe it shows he killed them. So I ask you to return a verdict of guilty. I rated Mr. McLeland's closing argument as hitting a single. I considered it hitting a single because he's a good storyteller. He can tell you a story. But what he didn't do is what you really need to do in your closing argument, which is to explain why his story is what you should believe. And so this just continued the prosecutor's theme of burying his head in the sand and ignoring the evidence that is contradictory, pretending it doesn't exist, not acknowledging it, even to the point of distorting some of it to make it fit his theory. An example of this: nobody else out on the trail matched the description of Bridge Guy. Well, neither did Richard Allen. He also didn't match the description. And you really need to have an explanation for that, but he hasn't. The description of the murders happening, he made it very graphic. She's clutching at her throat. There's blood everywhere. It's very graphic. But you haven't explained the peculiarities of this crime scene. Why is Abby just sitting there waiting to be killed while she's watching him kill Libby? How does this work? Nobody's crying out. Why are Abby's hands pristine and her torso pristine? Something that the medical examiner has never seen in his entire career with an injury like this. He's never seen clean hands because it's an instinct to reach for it and try to hold it. No explanation for the why is Abby partially dressed in Libby's clothes? When did that happen in this time frame? He has 7 minutes, according to Mr. McLeland, to have his way with the girls. It's a lot of time. A lot of time to be doing things that would leave trace evidence. But none was found. So in some respects, Mr. McLeland's argument, it was just kind of pounding on the table of, I want you to believe this, but not giving us the reasons why we should, and not overcoming the problems with the case that suggest that, maybe this theory is wrong. And that's a big oversight. It's a big oversight because the jury is going to remember what they saw. And so you trying to characterize, for example, the interviews, Richard Allen getting angrier and angrier, they saw with their own eyes. They saw with their own eyes how he behaved. And no, he did not get angrier and angrier. He didn't get angry at all. He stayed remarkably patient and cooperative, despite being treated pretty badly. And so his approach was basically, I'm going to tell you the story. I'm going to use the evidence that helps me, or my distortions of the evidence that helps me, to tell that story, but I'm not going to address the totality of the evidence in the case. Then I'm going to briefly talk about the elements, and then I'm going to tell you the story again. It's not persuasive. It's not persuasive when you don't give a why. The closing is not about the what, it's about the why. And he really never gave us the why. Why should we believe Melissa Oberg over Dr. Warren? Why should we believe that Rayleigh and Bree were the girls that Richard Allen saw on the trail? When he said he saw 3, they said they were 4, and the man they described looks nothing like him. They didn't even identify him. Why should we believe that Richard Allen's Ford Focus is the one on that video, the Hoosier Harvest Store video, when we already know there could be like 70 or more similar looking cars in this general area, in Carroll and the surrounding counties? A lot of the people out on the trail that day, they came from out of county. Cheyenne, Shelby. So the why was unsaid, and it's just not a strong position to be in. So it was like a solid like bunt kind of single, like a Ichiro slap, slap base hit. Got the job done as far as telling the story, but that's really all it did. You're not in scoring position after this closing. That was my opinion of it. He spent just over an hour on this closing, so we took a break, just a short break. We're able to look downstairs and see that the large crowd is already assembling for the after lunch. Mr. Rozzi steps up to give the defense closing. He says, "We've been here for almost a month. It's been 17 days of testimony, over 60 witnesses, over 300 pieces of evidence and video. We've had an opportunity to consume all those. This is our chance to tell you our theories of the case. But you can and should consider the tone and the words and the consistency of the witnesses when they testified. I submit to you the evidence shows 4 main themes over the last 17 days. 1, a broken timeline. 2, bumbled ballistics. 3, false confessions. And 4, digital forensics, the raw data that speaks the truth." The theme, he says, when you're in the defense position, it's one you can't really plan for because you don't really know what you're going to get. But the theme, there's like another theme here, which is about what they don't want you to know. And that might be the most important theme of this case. It's about what they didn't tell you, and we had to. Over and over, witness after witness, exhibit after exhibit, we had to do their job. There's the refusal to do the height analysis on the video. They inquired into it, knew that it could be done, but they chose not to. They said they were concerned about variation, maybe 2 to 4 inches. He at several times would say, "You're the, recall your notes. I, maybe don't remember specifically off the top of my head. So refer to your own memories for that." So it could have been a variation of maybe 2 to 4 inches, but that could have maybe ruled people out. Which, yeah, unusually short man like Richard Allen, 5'5". 5'5" honestly seems tall to me, just from seeing him in the courtroom. Yeah, potentially could have ruled him out. Hours and hours of video interviews that were lost during the critical time period of the investigation, early days of the investigation. There's the forward focus. Someone on this jury asked a question, and only then they ran down to the Department of Motor Vehicles to do a search in the middle of trial, and then offered up only part of the story again. We had to offer up the rest. Brad Heath never acknowledged the man who drives in that area, who notices something unusual that day: a car parked next to the CPS building. And it may not be the most important or the strongest piece of evidence, but it's something that we had to tell you and the state didn't. Betsy Blair, when the state called her, they asked only the questions to get the information they wanted to elicit. We had to bring out on cross that the man she saw, she described as youthful, boyish, with brown poofy hair, and probably not short. We also had to elicit that the vehicle that she saw parked at the building, he misspoke and said the Hoosier Harvest Store building, but he meant the CPS building. But the vehicle she saw parked at the Hoosier Harvest Store building was entirely inconsistent with a 2016 Ford Focus. Sarah Carbaugh, he's very dismissive and a little bit contemptuous of Sarah Carbaugh, which is a little bit risky. Like I almost don't even need to talk about Sarah Carbaugh, but she didn't tell the whole story until cross-exam either. That her reports were entirely inconsistent. That first she saw a muddy man. She said that 11 times when she's first interviewed, immediately following the crimes. Then weeks later, she sees a man with a tan jacket right up until they show her a photo of Bridge Guy. And then she decides it's him. They inflate the muddy and the bloody when they describe Sarah Carbaugh's statements. You are the judges of credibility of the witnesses. I'm just going to plant this in your brains. You may discount a witness's testimony entirely. As defendants, defense attorneys, we come across an idea sometimes that he calls incredible dubiosity. And it just means that something is so incredible and hard to believe that you should discount it entirely. I submit to you that Sarah Carbaugh's statement should be disregarded entirely. There's David McCain. They didn't even bring him in. We did. He was on the trails between 2 and 3 o'clock and spent no less than half an hour on the bridge. And they didn't tell you that because it didn't fit their narrative. Shelby Hicks and Cheyenne Mill were also out on the trail that day between 2 and 3 p.m. Cheyenne Mill was out on the bridge at about 3:59. There's Rick's version of the route he said he traveled. Investigator Mullen got on the stand and tried to put him on the route that he wanted. And he didn't tell you Rick actually said he didn't know which way he went. I don't even think it's that strong, honestly. From the interview, my recollection is Rick said, we would have gone this way. I'm familiar with this other way. But no, we would have gone this way. I don't recall him saying he didn't know which way he went. Then the interrogations, it wasn't until Mr. Baldwin wanted you to see them that you got to. And you can use your common sense to those. There's 2 pieces that you can and should use. Digest what's said and how, and then ask yourselves how Richard Allen handled that situation when he's being accused of murdering 2 girls, and ask yourself if you would handle that situation the same. Kind of put yourself in his shoes. Brad Weber's results from his gun. His gun could not be excluded as the gun that cycled that round. We showed you a photo from Brad Weber's garage shortly after the murders that shows lots of sticks on the floor. There's Brad Weber's statement to police. He said he drove home, but he's actually interviewed with Poole and Goatee when he says that he did not go straight home that day. He went to take care of his ATMs. The April 3rd phone call. They teed this up, this one call that was in a series of 3 calls. There's one right before that. And you might find it suspicious why you didn't hear that one. So why not tell you? There's the FBI being let go from the investigation. There's the sticks not collected from the crime scene that David Doolin had to go and ask them to come back and get them. Then there's those videos from Westville. 13 months he sat in that isolated cell in that prison. And all they want to talk about is what he said after sitting there for 6 or 7 months without any human interaction of substance, of meaning, being shackled every time he left his cell. Why wouldn't they want you to see the truth? You need context. You need truth. And then there's Oberg. Those infamous photos. The magic bullet that was the catalyst for Rick's arrest. You saw the statements, Lieutenant Holman's statement, his interrogation, used that bullet to try to leverage Rick's confession, to try to get him to confess. And it was a big part of the case because without that, they wouldn't have arrested him. But according to her testimony, she drew a conclusion, and you should just believe her and ignore the work product that she generated. And the state not only didn't offer that, but objected when we did. Use your common sense. Mr. Rozzi is getting a little elevated. Finally, there's the cell phone data. They didn't tell you that at 5:45 p.m. on February 13th, there's an audio output start entry on the state's own timeline. And that means someone plugged the phone into an accessory. His own report even notes that it's headphones. At 10:32, the audio output ends. Then at 4:33 a.m., the phone comes back to life, and there's no explanation offered up for this by the state. You should question the credibility of this investigation. Then there's the chapter of desperation that unfolded over the last 3 weeks. They got the round, they interrogated Richard Allen, and they arrested him. Then one unique fact that they mined out of months of therapy notes, videos, and phone calls. Yet just recently, they're running searches, talking to Brad Weber, trying to retrofit that unique fact to their theory of the case. Brad Weber said that he received a phone call from Mullen, and even he said that he generated text messages before he went to the police department, but you didn't see any of those. You also didn't hear about the 2017 interview where he said he was that day. He said he normally drives his Subaru and doesn't go straight home before he services his ATMs. The 2016 Ford Focus search, they had 7 years to figure that out, and they did it a week or two ago. And even DNA was being tested a couple of days ago from items that were collected 7 years ago. They came with internet searches. In October of 2022, he says that they're by Richard Allen, but there's no proof that Richard Allen made these searches. It came from an email account registered to Richard Allen. Someone in Delphi is searching about the Delphi murders? Well, we're going to convict half the people in Carroll County under that standard. They're desperate. Conducting searches for a movie? We would convict half of Carroll County under that standard. During the break, when the phone data came up, First Sergeant Cecil ran down and did a Google search. The kind of search he testified he would not normally rely upon for part of his analysis. This is absolute desperation. Then there's Dr. Core. We deposed him in March. And then he said there was more than one murder weapon, one straight, one serrated. But between his deposition and his trial testimony, all of a sudden, ta-da, it might be a box cutter. Of all things on the planet, that just happened to pop into his mind. And it's after 3 times he met with the prosecutors. And he's testified hundreds of times over the course of his career, but he never produced a supplemental report, never thought to give a heads up, hey, I changed my mind about this important detail. The 213 video is one bookend. The 357 time when Sarah Carbaugh saw whatever she saw, he's still being very dismissive. He said, it's not unreasonable to think to yourselves, I don't know if she saw anything. In the middle, at 2:32, the phone was silent. It was no longer functioning, where it was recovered the next day. Betsy Blair described the man she's seen as beautiful, boyish, with brown, poofy hair, and he didn't seem short. None of that is consistent with 5'5" Rick Allen. Maybe because she saw someone else. Sarah Carbaugh, let's not waste any more time on her. At best, she created what she saw by being offered up the photo. He describes how sometimes you see on TV when police will show somebody a photograph to identify them. And he says you're more likely to get an answer that you want if you only show 1 or 2 people. That's called suggestibility. Why aren't Shelby, Cheyenne, and Dave McCain in the timeline? These are people that were on the bridge between 2 and 4 p.m. Mr. McCain was there first. It was a very nice day. The sound, there was testimony that you could hear people on the bridge from down where the girls were. So it goes to show the sound carries in this area. And the girls, as the crow flies, are not all that far away. Shelby Hicks arrived around 2:30. She's on the trails when she receives a call shortly after 3 p.m. She passed Mr. McCain, sat on the bridge. She saw nothing. She heard nothing. Then there's Shelby Dunn and Cheyenne Mill. They went all the way across the bridge, got the timestamp on their phone showing that at 3:49, they were on that platform. They smoked. They heard nothing. They saw nothing. Dr. Kaur said it's medically possible each of the girls could have lived 5 to 20 minutes with the wounds that they suffered, and their vocal cords were not severed. But no one saw or heard anything, not a peep. The state has completely ignored the possibility of multiple actors because it doesn't fit their theory. We know there are lots of cars and people around this day. We know there's a possibility of accessing the area from the south side of the bridge. And Teresa Liebert said she saw a strange man earlier that day. So it's possible there was activity on the south side. Former Sheriff Lesenby, in his statement, said that there was possibly more than one person involved. And Dr. Kaur originally said that there were multiple weapons involved. So all of these lead to the possibility of multiple actors. On February 13th, if their story is accurate, Bridge Guy led them down the hill, across the street, inflicted wounds on one while the other was controlled, redressed, placed the sticks on the body, all in this time period between 2:13 and 2:32. That this suggests multiple actors, even if you believe their theory. They say this was all done by a 5'5" man with no sound, no DNA, no detectable trace evidence. The prosecutor told you in voir dire to use your common sense, and now is the time to do that. His theory is implausible. In 2017, days after the crime, Richard Allen holds himself out to law enforcement. He picks up the phone. He offers to help. He gives his phone to Doolin. And even Doolin says there's nothing unusual about that meeting. Even in 2022, he was cooperative with police. He came into the station, he was interrogated, and he told them he didn't do it. Then on October 26th, even knowing he's a suspect, what does he do? He goes back in the face of all of the lies and the Reed technique, all of those lies about the bullet, about his voice being identified from the video, about witnesses identifying him on the bridge. He asserts his innocence. The state wants you to believe that because the tone of his voice changed, you must believe he's guilty. That's insulting. If you were under this pressure, I submit you'd do the same. They even leveraged his wife. And he told her, I don't know how this bullet got there. And for 5 years, Richard Allen lived right here, right down the street. He had every chance to leave, but he had no reason to do so because he wasn't the one who did it. The bullet, this is the bungled ballistics. It's collected under some leaves in the woods. It's poorly photographed. Oberg eventually receives a firearm from Richard Allen's house. You heard about confirmation bias in these examinations, that it's much better to be blind. But you heard they'd had conversations about what they thought the source of that bullet was, a Smith & Wesson or a Sig Sauer. But when Melissa Oberg took the stock rounds out of the cabinet there at the lab, 4 to 6 times she cycled them, the marks weren't sufficient to compare to the magic bullet. So she test fires them. It's a totally different environment, and she starts off comparing apples to oranges. It's possible it could be done, but it requires a lot more work, a lot more intensity, a lot more corroboration, and you need to show your work. There's subclass versus individual characteristics. He says, I'm not going to bore you with a lot of this, but just you must be able to distinguish between them or it's no good. She considered subclass marks as to the ejector, but not the other tools. And as for error rates, there aren't any for comparing spent to unspent rounds. Then came the photos. Of all the things in a case that should concern you and cause you consternation, you should look at these photos. Take a look at them. Where in the hell is the sufficient agreement? Item LL, if you believe there's a match there, use your eyes for yourself. Item NN, I don't know how you get any meaning from that. Item MM, I don't understand the materiality of it. And item OO, maybe the most notable in this case. There's some similarities there that are kind of close, but both Melissa Oberg and Eric Warren identify those as classic subclass characteristics. And it's a really good example of why this is a dangerous business. Call it an applied science if you will, but it's under fire. The Rhode Island lab was closed down as recently as a month ago because they were unable to distinguish between the subclass and individual characteristics. This is a subjective game, and you've been told you should just ignore these photos and just believe me. That's what she said. So why didn't Mr. Allen, the defense, have the bullet examined? Well, it might be they were told there was no point in doing that because the work done was so poor. It's also not our burden of proof to prove his innocence. Why didn't they get it re-examined? They had 7 years. Then those false confessions. Richard Allen's situation is unprecedented. The warden said he's never had a pretrial detainee without criminal history in the WCU, and Dr. Walla acknowledged the same. Even Dr. Martin, with all of his history in prisons, told us the same thing. Mr. Allen was a fragile egg. He had a serious mental illness. That was cleared up by Dr. Martin that major depressive disorder is a serious mental illness. Dr. Westcott said he had a serious mental illness. He's tossed in the most secure unit in Indiana, and he's treated just like the rest. Like the convicted murderers and the child molesters, those were his neighbors, the most heinous people in the state, and he was treated just like them. He's immediately placed on suicide watch. No man, no matter how strong, could endure those conditions for that long without suffering some kind of breakdown. Where his cell is stripped down, he's left to eat off of the floor, competing with mice and ants, while his neighbors call him a baby killer and tell him to kill himself. When he got out of his cell, he went to a similar cell for his wreck. It's a cage with a screen on top. You recall asking Gallipo about all the rec areas? They have yards all over that facility, courts, playfields, and he never saw one. When he got to go to therapy, he was shackled, put in box restraints, a belly chain, a lead that we called a leash, and he was walked to a cage down the hall. Same with the shower. Then there's the 30-day rule. Here's the point. Solitary confinement is damaging to a man or a woman. It doesn't matter if the legal designation is a safekeeper. If you're held, you're eventually going to break. And here, 30 turns to 60, turns to 90, turns to 120. And when the dust settled, he was there for 13 months. How much can one human endure? They didn't want you to see those videos. It's insulting. Harshman said he was right where he belonged. But they could see he was psychotic from March to June. They want you to cherry pick somewhere in the middle when he became psychotic. He's getting stuck with needles that whole time until mid-June with antipsychotics. You can infer that means he is psychotic. They told you he was faking, but they didn't want to show you his body language when he was saying those things. And even Dr. Wallace said, in hindsight, she didn't know about whether he was feigning. And even Dr. Martin changed his opinion right on the stand after watching that video. Who could watch that video and think Richard Allen was oriented to time, person, and place? The standard at Westville was simply to keep him alive. You should be insulted. Gracian talked about false beliefs, false memories, that he's seen this time and time again, how false memories start out as false beliefs. Go look at that April 3rd phone call. Go to page 4. I did it. But by the bottom of the page, you see signs of the false beliefs. No, I evidently did. Maybe I did. I think I did. Couldn't remember calling his dad. I think I did because I think I did. I wish I could say I didn't. I just don't know. I just wish they'd kill me and let me apologize. So that must be what he said that I couldn't quite hear. I wish I could say I didn't. Wish I could say I didn't, but I don't know. These are classic indicators of false beliefs, according to Dr. Gracian. Then there's Libby's iPhone 6S. Does it ever have stories to tell? They want you to believe their story is accurate, but how do you interpret this info? 545, 1032. A phone has no personality, no feelings, no emotions, no opinions. It just generates data. And the data leads to one simple conclusion. Someone was using that phone. The phone went dead after 4:33, but we have the Apple Health data from earlier. It shows a 20-foot change in elevation. I invite you to revisit the map of the south side of the bridge and the testimony that the distance from the top of the bridge to the water was 65 feet. Use your common sense. Look at Weber Road. It's about halfway down. I don't know at what point 20 goes to 30 feet on the phone, but the relationship of the road to that distance is curious at best. That road leads to Brad Weber's home. He had sticks in the garage. He had a Sig Sauer that couldn't be excluded. The burden of proof rests squarely on the state, not us. They had 7 years to figure out 545 and 1032, and they have no explanation because the phone is right. A box cutter, Dr. Corr's testimony is hard to swallow. It seems like retrofitting. Also, a box cutter is one of the most common tools around. There's not a single piece of trace evidence on any of it, any of the things recovered from Richard Allen's home. There's no evidence he discarded it. It's just a statement that he made. A van, it's a van. How many vans are there in 2017? Westcott noted that medical notes, her summary of what Richard Allen told her from Dr. Walla, flowed like a story. But he was in a psychotic state for 4 months. No man in that state could talk like that. Dr. Walla's issues in this case are something you need to tackle. I would use the word bizarre. She has an infatuation with the case, and she didn't disclose her interest in it until after she began treating him. It is fair to question the accuracy of her reports. Looking now at the confession, lying in wait, does that look like it? The testimony was that he was on the platform, that he walked down the trail. Then they want to retrofit that you can hear a gun cycle. No, you can hear leaves crunching and the ordinary kinds of things that you hear in the woods. They want you to pick one thing out and say that's a gun cycling, but there's no proof of a gun cycling. They want you to believe Richard Allen was an alcoholic because of the testimony that he bought a six-pack and drank beers. But there's no reference to that in the intake. He drank a few beers socially. It's desperation. The search for the girls has been called into question. Sterrett said the search went on for hours until 2 a.m. on both sides of the creek. They weren't looking for dead girls. There were no leaves on the trees. You could see a couple 100 yards from the cemetery. They have lights. They're on foot. They're moving hastily to cover ground. This leaves lots of questions. Richard Allen is supposed to be lying in wait, but he's walking with purpose. This suggests he had a plan, that he must have known the girls, but there's no evidence of any connection of any kind with Abby or Libby. They say he's wearing the exact same clothes as Bridge Guy, a Carhartt jacket. Boy, that's a revelation in Carroll County. A Hope box with a .40 caliber Smith & Wesson round. It's a very common round, and they couldn't generate comparisons between cycles on that round to those on the unspent round. Richard Allen found the Lord, and that's why he confessed. Come on. He was stuck in that cell with nothing but that Bible for months. He's not the only guy who's found God while in prison. The voice on that video, Harshman identified as Richard Allen, but even Mullen told us that phone call after phone call, tip after tip, they received saying, I know whose voice that is. It was dozens, maybe hundreds, but somehow Harshman is able to identify Richard Allen's voice. Use your common sense. Regarding your common sense, look at the 10,000-foot view. No one identifies Richard Allen as the man on the bridge. Not Rayleigh Voorhees, not Bree Wilbur, not Betsy Blair, not Sarah Carbaugh, and they're actually identifying people that are not Richard Allen. There's not one piece of digital data that connects Richard Allen to the scene. There's not one bit of clothing, a shoe print, or a fingerprint that connects him to the scene. There's not one speck of DNA that connects him to the scene, and there's not one piece of trace evidence. You bet your bottom dollar, if he was muddy and bloody walking down the street, as Sarah Carbod described, they'd have found trace evidence when he got into his car. It is unprecedented in the modern era that they'd have no forensic evidence whatsoever linking him to the scene. We have been here a long time, but not as long as the Williams and the German families, not as long as what Rick and his family have had to endure. The state's timeline has crumbled. The magic bullet is nothing more than a tragic bullet, the catalyst that landed Rick in the Department of Corrections. At the end of the day, they want you to ignore 545, 1032, and 432, but the phone doesn't lie. It's nearly impossible he committed these crimes. Even if you consider confessions as proof of guilt, look here, and he starts to display images on the screen. This is a rack. He's showing like a picture from a museum that has like torture implements on the wall. This is a rack. This was used to punish people. He shows photographs, like illustrations of the rack being in use. Thumb screws. Shows a photograph of some thumb screws. This was a medieval device used to interrogate people. And they show a photograph of the thumb screws, not a photograph, but like a drawing, an illustration of the thumb screws being applied. As a society, we've evolved. These gave way to other forms of interrogation that are more subtle. Now it's locking someone in a cell and throwing away the key. We call it solitary confinement, but it is more lengthy and more painful. Whether negligent or reckless, someone should have spoken up. The doctors, the officers watching every day, at any time, is anyone going to say, this isn't right? Where's our moral compass? Every once in a while, we're reminded of circumstances that redirect us to a new direction, a new way of handling things. That time is now. He shows a picture of a boa constrictor, like an illustration, kind of like a political cartoon. That's the power of the state and the power of big government. Now is not the time to step back. It's time to step into the ring, to have a voice, and to acknowledge this isn't how we function. No person should be treated like this, guilty or innocent. But a verdict of guilty endorses this. We're asking you to set Rick Ellen free and to find him not guilty. That closing argument took about 90 minutes. It got us until noon, and at that point, we took the lunch recess. I scored Mr. Rozzi's closing argument as a double. I thought he made very excellent points, but the organization left a lot to be desired. There was several attempts to organize it around themes, but they didn't really play out. The bungled ballistics, for example, was kind of mentioned, but then it never really drew together what was bungled. The ballistics got mixed in with the stuff about the state's desperation, the desperation theme. So it did have a tendency to potentially come across as a little bit rambling. But the actual points themselves, drew blood. I mean, there was damage done here. I don't think it's out of the park. Some of the explanations I thought left a lot to be desired. The van, I really wanted to see that circle closed. Like, go ahead and say it outright. Dr. Walla, she's a weirdo. She's following all this stuff on the social media and on all the chat rooms. And she told you she was talking about that with Mr. Allen. And you also heard testimony from Cheyenne Mill about just what a shit show social media was in the aftermath of these murders. So is it really so hard to believe that there was conversation about a white van, that there were, parts of the investigation that considered white vans, and that either Mr. Allen picked up on this from his discovery and incorporated it into the memory that he is creating, or simply that Dr. Wallach fed him that fact. Is that so hard to believe? Because did she really have his best interests at heart? You saw the videos of how he was treated and what his condition was, and this is the woman entrusted with his mental health, his well-being. And yet look how she allowed him to deteriorate before there was any intervention. Something like that to close the circle. I would have really liked to have seen that. Some of the things like the Google searches, they never proved it was from his phone, is from his account, that he's the one that did it. It's just from his Google account. That's kind of a lawyerly thing to bring up. It sounds defensive. It's like there's a lot of targets you can shoot down, but you don't have to shoot down every single one. You really do need to prioritize. If you shoot down too many, it does kind of make it sound like, well, you just don't buy anything. There's nothing. You get more credibility, I think, if you acknowledge that there are reasons. Like, you can understand why the circumstances maybe look suspicious. But here's how we can resolve that. And so if you just focus on like knocking down every detail, it doesn't give that impression that you're kind of open to the possibility that people on the jury might be on the cusp, might be wavering, might not be real sure. They've got suspicions, and they need you to be able to put those to rest. So, the Google searches, I thought that the real point with those is that, the one that he made, who hasn't searched for a movie on Google? Who in Carroll County doesn't own a Carhartt jacket? Like, those points I thought that he made were solid. The other thing that he did that I think is always a little bit risky, and I called Mr. McLeland out for this in his case. I am gonna use it as a critique of Mr. Rozzi here. It's always a little bit dangerous to substitute tone for substance. When you let your tone express how you feel about the case and about how your opinion of the credibility of the witnesses and so forth. I understand there's like an idea of kind of leading and pacing and trying to like capture the jury to get them to share your emotion. But the problem is if they aren't already there with you at the starting point, if there's anybody on the jury that has, for example, sympathy to Sarah Karba, they think maybe she just, she's trying to come forward and say what she saw, and now she's being attacked. And so, yeah, she's defensive and angry about it. And she's been attacked on social media. She talked about that, so maybe they have some sympathy for her. Then it's not real helpful to treat her, kind of contemptuously. It's going to be off-putting. So that is a risk. That is a risk with this type of argument. Now, the advantage that Mr. Rozzi has while he's delivering his argument is he's able to gauge the feedback, the reaction that he's getting from the jury, their receptiveness. He's standing right in front of them. He's looking at them. They're looking at him. So, as far as whether it was a risk that didn't pay off or did, he's going to be in a better position to judge that than I am. But I do just know that can be a risky strategy, because you don't want to set yourself up in opposition to the jury. You want to be in alignment with them. You want to express that you can understand why they might think the way that they do. You can understand why they would come in and they would want to trust the state and the investigators, and they would want to give justice to Abby and Libby, and they would want to believe that this was a professionally done investigation and that it produced solid evidence that we can rely on to say we found the guy, and now we can close this matter and we can all put it behind us, and move on. And there's a strong incentive to believe that. But the evidence shows us you can't do that in this case. You got to be able to get on the page of the people that are skeptical. And so I really didn't see that from either Mr. McLeland or Mr. Rozzi. Both of them were fairly entrenched in their points. I just think Mr. Rozzi did a far superior job of explaining the why we should have doubts. Why we should have doubts. Just this item after item after item of the things that the state didn't address. And it goes on and on and on. This long list of problems. Things that can't be reconciled with their theory. So that's why I gave him a double. I thought it got them in scoring position. It was not a home run. He didn't knock this out of the park. He didn't walk out from that closing thinking there's absolutely no way the jury, his jury is going to do anything but acquit him. But it definitely gave them the tools that they need if they were listening and paying attention and they agree with him. He gave them everything they need to say there's just way too much doubt here. So we had our lunch recess. Like I said, it lasted about an hour. When we came back in, Mr. McLeland delivered his rebuttal. He said, it's been a very long 4 weeks we've spent together. There's been lots of evidence and testimony. Now we hand it over to you and you're in the driver's seat. So I'm not here to tell you how you should feel or when you should be offended. You're here to surmise the evidence. I didn't really understand what that meant. I don't think that's grammatically correct, but here to surmise the evidence. So when you go back to openings, the defense told you what they said the evidence would show. I submit they haven't done that, but you still aren't showing me why. You're just saying the words. You're not showing me why. I told you the case was about a bullet and bridge guy, and I submit we've shown you that. There's multiple witnesses that describe the man that they saw. It's bridge guy, and it affirms what Richard Allen already said, that he's on the bridge, he's in those clothes. We have a video from Libby's phone that shows the abduction is at 2:13. So the witnesses after that are irrelevant. At 2:32, the phone stops moving. That's hard evidence. They want you to think that because they didn't scream, it didn't happen. But Richard Allen had a gun. We know they didn't scream, but we know Libby was crying. We know that they were scared and that they were fearful, all because of Richard Allen. I would have objected to this. This is just inflammatory. It's not proper argument. Trying to get them to, this is the appeal to passion and prejudice, the appeal to the sympathies of the jury. Libby's crying and they're fearful and scared all because of Richard Allen. That's not proper. We know he left behind his bullet. I don't know how it's magic. It went from the scene to the lab, to the different people, to Ms. Oberg. And in her opinion, it was cycled through Richard Allen's gun. The gun he never loaned out to anybody. The defense wants you to look at these photos, but she told you you can't do that. But her results are verified. The defense witness could have tested the bullet, but he didn't. In fact, he didn't even write a report. Why is it a magic bullet? Because it looks the same. It links Richard Allen to the crime. I'll go with that. The defense has said words matter. Why don't Richard Allen's words matter? This was like, ooh, that's a good dig. Why don't Richard Allen's words matter? He made lots of them, gave lots of them to his wife, to his mother. He provided details to Dr. Walla. He repeats those details again. Words matter. He trusted Dr. Walla. You can hear it in his phone call to his mom. He confessed to his wife in front of Dr. Walla. He wanted her to hear. His confessions are organized, logical. They talk about details only the killer would know. The evidence shows Richard Allen is bridge guy and Richard Allen killed Abby and Libby. There are two victims in this case, Libby and Abby. But they're more than victims. They're also heroes. Libby for making the video, Abby for concealing the phone under her body, and both of them with, I don't know, I guess being near the bullet. These items helped police find Richard Allen. You remember Libby said sometime, "I'm going to grow up and help people solve crimes." That's exactly what she did, and she brought Abby with her. That was his rebuttal. It took 15 minutes. Not a very strong rebuttal. It's really not. More of the storytelling, the emotive, which is fine because everybody can feel for Abby and Libby and for the families who lost their loved ones. That doesn't have anything to do with whether you've arrested and charged the right guy. So I really didn't find it very effective. It was just kind of reasserting the things he'd already asserted in his closing about Melissa Oberg, and that's like really the only specific point that he responded to. They didn't scream means it didn't happen. No, that's not what they're saying. Now we're just kind of mischaracterizing. They're saying it doesn't seem plausible. And you haven't provided a very good explanation. Why wouldn't they scream? What else is there to lose when you're watching your friend be murdered? You have nothing to lose at this point. The point of the rebuttal, this did not advance the runner for Mr. McLeland, in my view. And I thought that was, he really left a lot on the table because I thought the defense potentially left him a lot of holes, and a big hole that I thought they left. I did not like how Mr. Rozzi ended his closing argument. It's almost a call for nullification. You should set him free. You can't endorse this behavior. You shouldn't treat anybody like this, innocent or guilty. I would have pounced on that. If I'm the prosecutor and I'm here to rebut what the defense is saying, I would have pounced on that. Sounds like they're saying even they think he might be guilty. And they think you should just give him a free pass to walk away because of the treatment that he endured in Westville. Now, Nobody thinks that's a good thing. Everybody struggled with that. Nobody liked to see it. It's hard to see. It's hard to watch. But that doesn't make him the victim. This case is about whether he killed Abby and Libby. And the evidence shows that he did. They didn't ask you to convict him because he didn't do it. They asked you to acquit him, to send a message. And that's not proper. I would have jumped all over that. All over that. Some of the things that are harder to explain, the van, since they didn't really close the loop on the van, point that out. They never told you. They never reconciled this remarkable coincidence that he just happens to mention a van in his confession, and Brad Weber has just happened to place his van on the south side of the bridge at the exact time that Richard Allen would have seen it. They've never explained how he would have known that. He just happened to include that detail that just happened to line up with what Brad Weber says. Just some of those weaker points that they didn't really address as strongly. That's what the rebuttal is for. You jump on those, you find the holes. This is counterpunching. He's shown you his openings and you take them. So in that sense, Mr. McLeland really did not let his hands go in the rebuttal. I'm mixing all my metaphors now between the boxing and the baseball, but yeah, really didn't move the runner at all. I didn't think. So at this point, the jurors are released. They're sent back into deliberations. It is right about 1:30 in the afternoon. It's quite a bit earlier than I thought they were going to get started today. I just, given the amount of time that the judge had allowed them to take for their closings, I was thinking maybe 3:00. that they would have enough time to sit down, choose their foreman, start to kind of discuss generally where they might be at, but really not have a lot of time to get into substantive deliberations today. But it turned out that, they were able to get started quite early. So she first instructs the alternates that they are allowed to accompany the jurors into the room, but they are not to participate in the deliberations. She's now giving the more general instructions. The state has the burden of proof, the defendant guilty beyond a reasonable doubt. Proof beyond a reasonable doubt means that you are firmly convinced of the defendant's guilt. There are few things that we know with absolute certainty, but if there is a real possibility he's not guilty, you must give him the benefit of the doubt and find him not guilty. A real possibility. It is the state has a strict and heavy burden. A reasonable doubt is a fair, actual, and logical doubt that is based on reason and common sense. You have reasonable doubt if you are not firmly convinced of the defendant's guilt. This is all very, very strong language for the defense. If you're not firmly convinced, this is another tactic that people will often use in their closing arguments. When you have good language in your jury instructions, you use that and you tie in your argument to that language. So that's something that was possible that the defense could have done as well. You have to be firmly convinced. If you're not firmly convinced, so are you firmly convinced that Betsy Blair saw Richard Allen on the bridge when she described him as boyish, beautiful, and with brown, poofy hair? Are you firmly convinced that Rayleigh Voorhees and Bree Wilbur saw Richard Allen on the trail when they described him as tall, much taller than them, they themselves being 5'7", muscular, wearing a hat, had his face covered? Are you firmly convinced that Sarah Carbaugh saw a muddy, bloody Richard Allen walking down the street in the middle of the afternoon after, according to the state's theory, he avoided the trails after killing Abby and Libby to avoid detection? But then he goes to a more populated area, a roadway, where anyone passing by is going to be able to see him? You can really use that to your advantage. Are you firmly convinced? The standard is not met by proving the defendant is probably guilty. The rule of finding proof beyond a reasonable doubt, it applies to each juror individually. You must not vote to convict unless you personally are firmly convinced of the defendant's guilt. The defendant is presumed innocent. That presumption continues. You must fit the evidence to conform with the defendant's innocence if that is at all possible. If there are multiple interpretations of the evidence, you must use the one that favors the defendant's innocence. I would have used that to talk about the bullet. The bullet. The state wants to tell you it is. We got a guy here who tells you it isn't. You can see the photographs for yourself and it doesn't look very close. You got to adopt the interpretation that favors Mr. Allen here. The defendant is not required to present evidence to prove his innocence or to prove anything at all. The jury is the exclusive judges of the weight and the credibility of the witnesses. They should attempt to fit the testimony to the presumption of innocence with the assumption that witnesses are telling the truth. You should not disregard testimony without a reason. Certain things in the court have been, in the trial, have been ruled not to be admissible, or you have been instructed to disregard things. You must not concern yourselves with the reasons for those decisions, and anything that you've been instructed to disregard, you may not consider as part of your deliberations. Nothing I have said to you is a direction to you as to what you should find or the verdict you should reach. There will be no testimony read back to you, and no exhibits that were not admitted will go back to the jury room with you. The verdicts must represent the considered judgment of each of you. They must be unanimous. You should not abandon your conviction for the sole purpose of returning a verdict. You may discuss the deliberations and your decision after, but you are not required to. When you reach a verdict, you should inform the bailiffs that you've agreed after the verdict forms have been agreed and signed. Neither sympathy nor prejudice should affect your judgment. Don't concern yourself with the punishment that may be imposed. That's on the court. They are providing verdict forms to you. You should first select the foreperson who will preside over the deliberations and who will sign and date the verdict forms. The bailiffs are then sworn, and at 1:25, the jury is sent to deliberate. The bailiffs are sworn in because they are charged with the care of the jury, and so they're basically swearing that we will, keep them secluded and we will not allow anybody to have communication with them and so forth. Mr. Baldwin asks after the jury is out if there is a timeline for how deliberations are going to go. Judge says, well, she's anticipating they would go back to the hotel at about 4 p.m., They would reconvene the next morning at 9. They would go again till 4. They do plan to go on Saturday, but not on Sunday. And they will have no access to their devices or to their families during the deliberations. And now we wait. So you have probably maybe heard that the jury had until 4 o'clock. But it was about 3:20 they asked to be released for the day. And I know a lot of people have a lot of thoughts about this, and people want to know what I think about this. I don't know. I really don't. But I will tell you, the thing that seems to make the most sense to me is that they are either in agreement or close to it. And the reason why I say that is because if they've started off with their deliberations and they're not particularly in agreement, then they're just really at the beginning. You would start the process of, okay, let's go ahead and work through the evidence and work through our points of difference and see if we can resolve them and so forth. Now, it is certainly possible that that's what they did today, and they just kind of realized, all right, there's going to be a lot for us to work through, so let's just go ahead and clear our heads for the day and go back to the hotel and come back tomorrow so that we can get to work. But I just kind of doubt that. I just do. It doesn't feel right to me. And part of the reason why is because this jury has been out for so long. They have been secluded from their families. It's very normal for the jury to want to get this done and go home. And they've had many days where they've spent, up till like 6 o'clock in the evening up there in that courtroom. The jury room, they have access to snacks. They can, they use the restroom. Like, it's not like being in solitary, So it just really seems to me that if they were coming out of this part of the process with a sense that they have a lot of work to do, they would have started to do that, because the sooner they can go home to their families, the better. Now, tomorrow is Friday. Would not shock me to get a verdict tomorrow, because there's a couple reasons why this can happen. One, yes, they do want to be careful. They do want to think about it overnight. They want to make sure that they've covered every base. They have had a lot of time already, as we've talked about, to hear the evidence, to form opinions about it, and even to discuss it with each other, to kind of pre-deliberate and get a sense of where everybody stands on the evidence that they've watched. So that's a real wild card for me that makes it hard to read what's going on, because I've never dealt with that type of arrangement where the jurors can kind of like pre-deliberate. It's like they get a head start on the process that they would ordinarily have to do entirely in the jury room. So it is very possible that, yeah, they just didn't really have a whole lot left to do to get to the point where they're in agreement. But it wouldn't surprise me at all. A couple of reasons. Not uncommon to just want to be very sure, take some time to think about it to be sure. I've had several people report to me that the jury has reached a conclusion very quickly, but they don't want to come across as insulting to anybody by, coming back right away. And so they'll kind of waste time. You got the whole afternoon, you're not going back to work anyway, chit chat, you got your free meals. I mean, whatever. Possible that could be part of it as well. My sense, if I'm a juror, I've been out for this long, I've been away from my family, I've only been able to talk to them briefly and maybe see them on the weekends. I'm going to want to go home for the weekend. I'm going to want this to be done so that I can go back and I can have time with them before I have to go back to the rest of my life, my job, all that. So that to me speaks to the possibility of a verdict tomorrow. But obviously, this is all tea leaves. You just never know what a jury is going to do. If there is anything that I have learned from speaking to juries, many juries over many years, it's that they can be very unpredictable. So we'll see. We'll see what we get. I'm sticking close to the courthouse while the deliberations are going on because the judge has suggested the attorneys are to stay within like 5 minutes. They want to be able to announce that a verdict has been reached and get everybody assembled and get it read quickly. They don't want us to have to wait. So I don't want to go very far. We've been having some conversations, myself and Bob Mata and Lawyer Lee, about it'd be awesome to do a round table, live stream while we're on verdict watch. And I really would like to be able to do that. And I hope we can find a way to make that happen. But I'm concerned about finding a place to do it that doesn't run the risk that we potentially wouldn't make it back in for the verdict. So I'm kind of trying to brainstorm it. If we do pull it off, it might be something ugly with just phones and I've got a little plug-in mic, outside of the courthouse, maybe. I don't know. Because I really would like to do that. I think it would be a good kind of chance to bounce our thoughts off of each other. But I am concerned about getting back into the courtroom for the verdict. And that's contributed to with just the chaos that is still out there, more and more media, arriving and, not necessarily showing a lot of respect for the order that we have managed to maintain so far. So we will see. We'll just see how all this unfolds over the next couple days. Guys, I am going to go ahead and start going through your comments. I am going to go ahead and repeat that because I am very short on sleep still and I need to catch up, I am shutting off the super chats if there are still any coming in at 10 p.m. Pacific. It's 9:17 right now. Pacific, I meant Eastern. 10 p.m. Eastern. It's 9:17 right now. So I'm more than happy to see your comments, talk about them, answer your questions and stuff like that. But I just want to be able to leave enough time for me to go to bed and get a good night's sleep. And if there are super chats in the queue, I will feel obligated to pull them up and address them because it means a lot to me that you guys care enough about sharing your ideas and your questions and things like that, that you will actually pay your hard-earned money to bring them to my attention. So I always want to honor that. Tilly T, Spa Fund. Hope everyone has a good day, rest of day. Ciao for now. Love from UK. Thank you so much. I am definitely I'm really not a spa person. I consider myself a pretty low maintenance person. I love to camp and stuff. I've told a few people just recently, I did a very long road trip down the Pacific Coast Highway from Astoria, Oregon, down to Los Angeles. I camped nearly the entire way. And then came back up inland through the mountains. So I went through King Canyon and Yosemite and up through Tahoe. And I mean, same thing, sleeping on the ground is kind of my speed. But after all this, I am going to indulge. I'm going to go get those special treatments that I don't even really know what they are, but they sound very appealing and restful. Linux 203. I wonder if the jury has a verdict but wants to sleep on it. Thanks for the wonderful coverage, Andrea. Yeah, I mean that's where I'm leaning. It's what seems to make sense to me about the circumstances. It makes more sense to me than that they're already like hung, already not going to be able to resolve it, because I think they would just have continued to work if that was the case. Amy, caught alive. I'm from Missoula, Montana, and close to your age. I love Missoula. So my grandfather lived in Missoula for many, many years. My father's family is from Montana. I love it over there. I very nearly went to law school there. Admire you greatly and wish I'd gotten a law degree instead of a business degree. Been watching you since Delphi heard. Thanks for your dedication and hard work. Well, thank you. My husband also has a business degree. It's a very useful thing to have. I have found his mind and the way that business education teaches you to think to be not just really helpful, like for me, because it's a different framework, but it really complements the legal thinking very, very well. They're both very analytical and logical types of thinking. So there's no reason why you can't do both. And it is a very good law school right there that you have right there in Missoula. Daniel Cole with a heart super chat. Thank you so much for that, Daniel. Really appreciate that. Amanda Lang, were you able to look at yes. Okay. So this rule, if applicable to a judge, what would a process like this typically look at? So this was a rule that's dealing with judicial discipline, and it sets out different standards for when a judge can be disciplined. This particular standard is referring to basically a pattern of misapplication of the law or the rules. So basically, like they're consistently getting it wrong. So the process for this is typically that there's a complaint made to the Judicial Commission, or whatever exactly the name is for the agency that handles judicial discipline. They investigate it. They decide if it has merit, and if it does, then they can go forward and require the judge to answer that. And essentially, it's like bringing a charge against the judge. It's just not criminal. It's an ethical proceeding. I would honestly be surprised if this rule is really got a lot of teeth. I mean, it's obviously there on the books and it's there for a reason. But I would be skeptical that it's ever really been applied very much, if at all. Just because there is a lot of tolerance for judges getting it wrong. Judges are very busy. There's a lot of law. They have to, often in a position where they have to make kind of knee-jerk rulings. And the people who review judges' performances, whether you're on the appellate courts or whether you're in a commission like this, they give the judges the benefit of the doubt. They want to put themselves in their shoes and think, well, is there any reasonable explanation for this that's consistent with just being really busy, just being really overworked? But I mean, I am very alarmed and disturbed, certainly, by what we've seen here in this case. We would have a challenge with being able to make a record of these rulings. I would suspect that it's probably the type of thing that you would have an appeal. So an appeal would, if there's a conviction, then there's an appeal. There's a record that's created as part of the appeal that includes the transcripts, the bases for the rulings and all of that, including all these sidebars that we haven't been able to hear. Under Judge Gold's interpretation of the rules so far, we're not entitled to that. We, the public, are not. That's the basis of the writ I've sent up to the Supreme Court. So unless there is a conviction and an appeal, I don't know that we would have that, like anybody would really have the basis to show, to be able to demonstrate, look at, here's this trial, look at all these rulings, look at how consistently wrong they are. And they're all consistently one-sidedly wrong, in a way that benefits the prosecution and damages the defense. If there is an appeal, that could be a different situation, especially if the appeal goes in Richard Allen's favor. But I am very skeptical that rule is one that is applied in a way that is particularly meaningful. But kudos to you for finding it. I certainly hadn't found that. Mad World, Jeff said, if not guilty, you've got to do a Dr. Spiegel impression. Oh, boy. Oh, no. There you go. You got my Dr. Spiegel impression. Oliver Messiaen, thank you so much for the important work you're doing here. In the event of a hung jury, would Goal definitely be the retrial judge? Unless she steps down for some reason, they typically do not reassign the judge, and especially in this case where they have a special judge assigned for purposes of this trial. Yep, I think it would be Goal again. Now, they could potentially ask for disqualification, but I don't think they would get it, just given the record that they made before when they asked for it. The Supreme Court was very clear. We can't rely on the rulings that she's made to establish that she's biased against the defense. So even though her rulings are, from my perspective, often wrong and very one-sided, they can't use that to say, look, she can't be fair here and she probably shouldn't be the judge. So unless she steps down, it would be her. Jadzia 1969, I can only imagine how much more emotionally invested you are having attended the trial and followed it so closely. Really appreciate your analysis, but please look after yourself. I do appreciate that. I will confess, I am one that will push things to the limit, if not a little bit beyond, but, at the end is in sight. And so there's going to be plenty of time to recover from this. My voice is still, not great, but I am, taking little baby steps, getting more sleep tonight, all that type of thing. Plain iron, tea and ink pens. You're keeping me up all night. Well, this case is. For what reason, I have no clue. Glad you're doing this great service for all of us. It's keeping me up at night. It's just, it shouldn't happen. This is not something that should happen in America. Just revelation after revelation. That's just jaw dropping. And all of them in the same case, It would have been enough to see this weak case being distorted and this deceptive presentation of it by law enforcement and by the prosecutor. That would be like a whole independent standalone, like get my attention in a case. But then we combine that with a judge who's like nothing I've ever seen. And 13 months of solitary confinement of a pretrial detainee. I mean, it's just really unbelievable. So it really has riveted me. I'm very invested in the decision, and I very much hope that we get a little bit of justice in this case. Jennifer Ferguson, what is it going to take to get to move to Allen AO and run against Goal next election? Me? No. No, it won't be me. It won't be me. But, people should start thinking about it. People local in this area, they should start thinking about it because this trial has gotten attention. And, I just have to think she could be vulnerable. I have to think she could be vulnerable to a challenger. So good time to start thinking about recruiting somebody who would do a better job. Stadeka, 1, if today was a 3L mock trial closing and you were a judge, who won? Mr. Rozzi, in my opinion. 2, which closing was the jury more responsive or reactive to? They were pretty equally responsive to both. And by that, I mean, they were not very responsive at all. They took very few notes. They didn't show the reactions. The only ones that I mentioned were the ones when Mr. McLeland was replaying the evidence, and the one juror, the one that's been having a lot of issues with a lot of the stuff that's been shown, seems to be like, maybe you shouldn't have reminded him of that. I don't know. By and large, they really do not come across as very reactive at all. Charlie Lynn, I hope the jurors have stopped early due to a long and heavy case and they decided to select the foreman and maybe do a poll, etc. Then decided to regroup and rest so they could start fresh tomorrow. Yeah, I mean, it's very possible. We don't know. We don't know what's going on. It is possible that maybe, they just thought we've had a lot of long days and a lot of stuff, and it's emotionally trying, a lot of the stuff. Every time you have to look at the crime scene videos, every time you have to look at the interrogation stuff, it's emotionally trying. And so there's been a lot of that. And I'm, a relatively jaded defense attorney. I've seen a lot of stuff, although never, like I've said, quite on this level. For the jury, it's very likely this is all new. And so, it could just be that They're just exhausted. They need a rest and they want to start fresh. Twigs, do you think the jurors will do their own investigation after the trial and feel like they've been lied to with the unfair bias against the defense? Well, I have given some thought to this because I do wonder if the jury, if the jury reaches a verdict and then goes home and looks into like what's been going on with this case. Why have all these people been in the courtroom watching this? They're aware that we're all there and that media is there and all that stuff. The courtroom is packed. So they know this is getting a lot of attention, even if they didn't, already suspect that coming in. And so it would be natural, to want to like look and see and then, learn about all the stuff they didn't get to hear, the geofence data, the third party culprit suspect stuff. And I would love to know if they reach a verdict and then they go and find that out, how does that sit with them? Because I can imagine, they would feel misled and they would feel deceived. And it really just drives the nail home on this argument the defense has made about look at what they don't want you to see. Obviously, this is stuff the defense would want you to see. And it's the state that kept you from being able to see it. Dieter, after a not guilty verdict, I hope all the current ugliness is directed at the shoddy investigation and not the jurors. I agree with that 100%. There needs to be some accountability, and yet there's never even been an apology for things that are obviously problematic. The videos being lost, not following up on any of that, losing the data on the phone. Not a single person that I saw ever was like, we're really sorry that happened. In small communities, people's names and faces can be easily recognized and harassed. Yeah, well, that's what gives me some hope for the fact that these jurors are not from Delphi. They're from Fort Wayne, and Fort Wayne is pretty big. It's a pretty big city. A few 100,000 people there. It's not giant, but it's not a small community like Delphi is. So their friends and their family and everybody are probably going to know, because they've been gone for all this time. They know they're on jury service. They're going to know that they were involved. But other than that, seems like a pretty good chance that if they want to, they can just fade right back into anonymity. And that's the way it should be. So I'm glad. I am glad that is one thing that Judge Gold did that I think she did right in this case, was to bring in this outside jury and not draw it here from the local community. The pressure just would have been enormous. It would have been enormous. Give the community what they want or else. Elvis on Velvet. Great name. I like that. Kept hoping defense would structure its closing argument to highlight how the state has fallen short of promises made during opening statement. Thank you for your heartfelt commitment to this case. Yeah, it is always one of my favorite ways because it lets you get in those digs. But it's also just very effective. It's a way to show they have the burden of proof, and that's what they told you they were going to be able to prove. And now look, they haven't. So how can you convict? What they told you were going to get, you didn't get. I find it very effective, but it is certainly not the only way to do a closing argument. Lori Lee Annie, thank you again. Later, after you have recovered, I would love a live with you and Runkle comparing the legal systems and prisons of U.S. and Canada defense. Yeah, I think that would be a lot of fun. A little comparative law type of thing. I've always been interested in just the Canadian / UK, very, very similar, the Crown courts and all that. It's just so different in some very, very fundamental ways. We do have a lot of variation in the United States that can make it a little bit challenging to do that. Like, I'll give you an example. There's a historical distinction that comes from the United Kingdom's justice system and the way that it was historically structured. This distinction between courts of law and courts of equity. And it's really hard to explain the difference between these things other than that law is really just straightforward applying the rules to certain sets of facts. And so it's usually about things like contracts, things like a tort, if there's a wrong that's defined by law and you prove that wrong has been inflicted, then you recover. They're usually focused on damages in courts of law. And then also courts of equity. Courts of equity are much more broadly concerned with justice. And so equity courts often have, they involve different types of remedies than just getting money damages. Equity is like your injunctions. Equity is orders to do things, to disgorge benefits. Just different types of things that are more about the weighing of the scales. And so some states in the United States continue to maintain this distinction. They have separate courts of law and separate courts of equity. Many states, they don't. They've just combined them all in the same thing. Yeah, I think that would be interesting. I always like talking to Ian. He's such a good human. Nell Wood, can we start an emergency fund to get Richard Allen and family, as well as the defense team's families, set up with some good security systems? Arsons with cause unknown happen way too frequently in that area. I will tell you, I have thought about this. I have put feelers out. I'm not going to go too much into detail, but I don't think it's really an option. And there's a variety of reasons to that, but they're largely personal to the Allens. So I know how much everybody wants to help and everybody wants to support, and maybe that will change. But at this point in time, I don't expect there to be any kind of prospect for people to be able to provide that kind of assistance to them. Cookie Harris, second big old cheers to you, your dedication to being in that courtroom each day, forensics, legal talk, and side doses of Walla Walla and Whistler dreams. Thank you for the light you are. Thank you, Cookie. Cheers to you. And you will make it to Whistler. I have every faith in you. And it is a pretty neat little town. It really is. It's like everything you would expect a little classic ski village to be. I actually got my coat, my big down coat that I've been wearing here when it's really cold. I got that in Whistler. I showed up there and I was under geared. The weather turned on us. So I got that nice big coat, one of the fancy stores there, one of the fancy ski stores, and I love it. Bridget Wainwright, were any confessions with details beyond "I did it" recorded? No. Even though he was recorded 24/7. Nope, not on audio. Not on audio. Just with Walla wasn't filmed. When was his last confession? The last one that they noted was the February 24th one over in Wabash. And it was just a simple, I killed Abby and Libby, reported by one of the guards. There were some inconsistencies in his report. It had the statement evolved, as he repeated it. So there may be some issues with the credibility of that. But that's why there was so much focus on, the possibility that psychosis could recur, and also just putting it in the framework of a false memory. If this is a false memory, you don't have to be psychotic to have a false memory. You just, it's false until you realize it's not. So I don't know what the jury is going to make of it. I know what I make of it, but it's ultimately up to them. But yeah, none of these were recorded. The ones on the phone calls, which were just like the classic, what even Dr. Walla described, they're hand in hand with his delusional themes, and what Dr. Gracian described, where it starts with a belief, not with a sensory type of experience. So they're just very classic, meeting that pattern. Mendy, shout out to Michelle Langstonin, Cookie Harris, Carrie, and Truth Seeker, who were bosses today and held the line. Teamwork for the win. Yes, the line sitters had quite a task today, and the folks who have tried to keep things organized and keep it civil, keep it moving, keep us all on the same page, notwithstanding the folks that don't want to be part of the solution. They want to be part of the problem. These guys have just been such an asset. I'm so grateful. All the line sitters and Truth Seeker, the time that she has put in. She's like an organizer, that girl. Okay. Like, Here's the time you need to be here. She's got people there. They're reliable. She's got it covered. It's just been a lifesaver through all of this. There's no way that we could have done it without her and without all of you. And especially you too, Mendy. Especially you too. My angel from heaven, Mendy. Jennifer Ferguson, is it common for a two-time murderer to trial only be 17 days? Yeah, I mean, not unusual. Not unusual. I did a double murder trial back in 2017, and I think it went 2 weeks. It went about 2 weeks. It doesn't always take that long. It just depends on what the evidence is. The squid, does the jury know that they couldn't exclude 3 other guns from being matched? Yes, that did come out in the testimony. If they do, that prosecutor is unethical for lying to them. Well, it gives them a reason not to trust him and not to trust the story that he tells. And that's why it's just, from my perspective, it's such a bad idea to play fast and loose with the facts like that, because the jury can smell bullshit. They can absolutely smell bullshit. And so if you're not prepared to address bad facts, you're not going to put on a strong case. And so it shouldn't come as any surprise if you don't get the outcome you're looking for. I said last night, we, the defense, we are used to dealing with bad facts all the time. That's kind of the nature of the job. People don't get charged because there's no reason. There's nothing that the state has come up with that casts suspicion on them. Even people that have been exonerated. You can go through and read the Innocence, some of the Innocence Project cases. Even the people that were exonerated, like, there was a reason for people to think they did it. It's just that for a whole variety of reasons, they weren't very good, and a lot of times, yeah, it is just a coincidence or wrong place, wrong time, or you just look a little too much like that other guy. It does happen. I don't see how that's even allowed if this is the case. He's not allowed. He's not precluded from being misleading. He's not presenting false evidence. It just kind of comes to the weight that the jury gives what he says. Most people don't like somebody who's misleading and not really very honest. So if they don't get the sense that he's been honest with them in his presentation of the case, then they're likely to reject what he has to say. Auto Doctor 911. Yogurt shop Ms. high school friend Mike Scott and one other made false confessions, eventually reversed, but still unsolved, even though evidence still exists. I also knew one of the girls murdered. Yeah, that's unfortunate. But yeah, this type of thing happens. False confessions are not uncommon. And I think this trial has kind of started to bring to light how that can happen. Just the enormous pressure that they can bring to bear on people. And it makes you start to question your own reality. I mean, most people aren't going to be held in a solitary confinement type of situation, but where you see this come up over and over and over again with this Reid technique and with extended abusive types of interrogations. Where they just go on and on and on, and they continue to hammer at you and continue to gaslight you, and they don't listen to you, and they keep insisting, and they yell at you, and they tell you, all the bad things that are going to happen to you, but how much better you'll feel if you just confess. And we all know you did it anyway. And imagine that for just like 16 hours, and you're getting tired and you're hungry and you just want it to be over. And people will start to think, gosh, they're insisting. Maybe it's true. Maybe I just don't remember. Maybe I'm going crazy. Happens way more than we would like to think. Santana Treto, where was Richard Allen the rest of the afternoon PM? Alibi? We never got an alibi, like alibi evidence. So we don't know. He just, as far as we know from his statement, he went home. He went home for the afternoon. He said he thought that the reason why he went home when he did was because he wanted to keep looking at the stock ticker on his computer instead of on his phone. Don't know if that's something they could have gotten data from to confirm. They had limited resources, the defense did to be able to dig into that. But I mean, we heard about all the review the state did of the evidence. Maybe it's in there. And see, someone on X said you went up to the girl's family and said you were there to make sure RA's rights weren't trampled. True. Thank you. I haven't missed a live. No, this is not true. I saw somebody make this comment on my YouTube channel, like, I don't know, maybe a week or so ago. I was like, oh, okay, this is a good heads up for me that we're entering the smear phase of trying to discredit, what I'm doing here with my reporting and stuff like that, because there are people that don't like it. There's a lot of people that didn't want eyes on this case. And, it's been my honor and pleasure to spoil their plans because trials belong to the public and they belong in the public eye. No, the only words I have ever exchanged with anybody in the family was the day that Becky Patty was giving out the banana bread, when she offered me banana bread. And I said, thank you very much. That's the only exchange with the family I've ever had. I've made it a point to I'm not trying to be intrusive. I'm not trying to, I'm not trying to interfere with their guilt or their grief or anything like that. So no. Nope, it didn't happen. It's a lie. Michelle H., thank you, AB. You rock. If when Richard Allen is acquitted, can the family of Libby and Abby request the FBI to reinvestigate without local law enforcement being involved? Pins, Tool Brand. Okay, I'll check out Tool Brand. I'm becoming quite the pin connoisseur. People are sending me all kinds of recommendations. So I have a lot of things to test out. No, probably not, because it goes to jurisdiction and who is going to have the authority to prosecute the crime. The feds don't have the authority to prosecute the crime unless there is some type of connection, some type of link that would give them federal jurisdiction. The feds don't generally have jurisdiction over just straightforward murder. Federal murder is typically a very specific type of murder, and it's usually things like it's murder involving a bank robbery, it's murder of a judge, it's things like that. And so not real sure that there would be any basis for the FBI to come in and do their own independent investigation. Annalise, New Zealand. Maybe Abby was unconscious from hypothermia if she had been naked. The cold was the greatest weapon in nature with two girls. Yeah, I just don't know that it would set in that fast. Unconscious from hypothermia. I don't know that it would set in that fast. I really don't. I don't know if there would be evidence of that in the autopsy, if she had been in a hypothermic state. Yeah, I don't know about that one. My gut reaction to it is, there's not enough time between the 213 and the 232, and especially with the state's theory, now it takes 7 minutes off of it. We're at 220 to 232, 12 minutes to get hypothermic and go unconscious. I don't really see it. But I'm not a medical person, so if there's medical people in the chat who know about that, by all means, let me know. Sarcasm FF. Thank you again, Andrea. You were so monumental to bringing us the details in this case. I am hoping you get some serious rest after this case is completed. I very much plan on it. That is top of my to-do list, is sleep a lot. Sleep a lot. Kristen with a C. Look up French ultramarine for a possible rosy color match. Okay, I will look that up right now. French aquamarine. That is giving me a little bit of his shirt tone. This very, very pale blue. I could see that. I could see that as less for the tie, but more for the shirt. The suit is a much, much darker blue. It's a much darker blue than the aquamarine. But yeah, the shirts I could see that color. That's very descriptive. I like it. I'll have to put that one in my vocabulary. DB blank, a blank super chat. Thank you, DB. I appreciate you. Thank you so much for being here. Jojo, in the Rittenhouse trial, I remember there was a huge issue of how you couldn't zoom in on the video because it automatically filled in pixels and gave you a false picture. I think of that every time Bridge Guy is brought up. Yeah, the enhancement is just super sus. You know, it just really is. It really is super sus. It seems to be feeding you much, much more than what's available on the raw video. And I've always wondered, like, is there some kind of AI predictive thing that's going on with the enhancements that they did? I don't know. They have done a lot of touch to zoom in the course of this trial with their big fancy screen, and they go in and they move things out and they push them back in, and it hasn't been an issue. Nobody's objected. So I do remember that being an issue in the Rittenhouse trial, but nobody's really brought it up specifically here. And nobody even, I mean, that was another thing, you know, the defense didn't really challenge any of that. I mean, maybe there's no real upside to doing that, you know, but it's just part of the sus, part of the investigation. These enhancements talk about, you know, showing your work. They just kind of said, well, we adjusted some levels and basically like Photoshop. Be nice to see that, you know. But I guess if the defense doesn't have an expert who's able to look at it and look at the metadata and see what changes have been made and all that, then the state certainly isn't going to volunteer that type of information on their own. Lissa M., have you read the Betterow letters and Turtle Boy's case? I sure have. The DA got busted going through Turtle Boy's phone, and DA used personal email to email a judge, pressuring him to change his ruling. I saw that, and the judge went along with it. Your coverage of RA's case has been badass. Thank you. Well, thank you so much for that. Yeah, they don't like what Turtle Boy's doing over there. And it's not a good look. Not a good look for the DA at all. Those letters are very, very damning. So if that stuff gets substantiated in trial, that could be a bad situation for old Mr. Morrissey. Wicked 513. Hi, Andrea. Love your unique insight into this case. Would Williams and German family have grounds to sue the police department for their negligence in investigating this case? No, they would not. And the reason why is because there is longstanding case law in the United States that the police officers owe no duty. They owe no duty to us. Nothing. They owe us nothing. They don't have to respond to the 911 call. They don't have to investigate your case. They don't have to give you justice. That's right. They owe us nothing. They just have power. They just have power over us. Now, I certainly think that most of them want to do that because they have a sense of responsibility and a sense of duty and an understanding that there's a reason why we have given them the power that they have over people's lives, people's privacy, power to pull people out of their homes and throw them in a cage. It's a lot of power. And I do think most of them respect and honor that, but there's no duty to. So no, there's no legal responsibility on the police department at all to do anything in a case. The crypto tax lawyer love. If you go to Idaho next year, I'm there. Sleep well. I'm definitely going to Idaho next year, so I will plan on seeing you. I would not miss that for anything. Stadeka, why was D allowed to argue Weber was a RESP third party sticks in the garage, but couldn't argue the other RESP third party persons, Odin Guys, Elvis? I noticed that in his closing, he really did skirt close to the line. Like maybe you should suspect him. I don't know if there's like a line to be crossed because they didn't specifically say Brad Weber did it, not Richard Allen. He's the real one. I mean, they're allowed to point out there are other suspicious circumstances. And if they're doing it in the context of suggesting like, how can you be certain about Richard Allen's guilt when there are these other open questions that haven't really been answered? You know, this other direction of suspicion that we haven't really seen. We haven't really seen that resolved. I mean, Brad Weber was eager to kind of volunteer on the stand about how the police stopped him, searched his car, searched his house, got a warrant, all that stuff. So, I mean, the jury heard that and they knew he was under suspicion. My guess is it's just that they didn't cross the line because they didn't actually say, Brad Weber did it. They just raised that, there are suspicious circumstances that point to him too. It doesn't even necessarily mean that he did it. It just means how can you point the finger so strongly at Richard Allen when the case against him isn't that strong and you got these other circumstances pointing at this other guy. So that's my guess. Harley Quinzel, if the jury convicts him, they will be very hurt to hear the truth after the case. I feel for them. Yeah. I think that would be a hard thing as a jury to find out that you had been misled like that. There's all this stuff that you didn't get to hear. The prosecution didn't want you to see. I don't think they're going to convict him. I really don't, but that is just my gut, and you never know. You never know what a jury's going to do. Ms. Jake, is there any indication that Abby and Libby's families think that Richard Allen did or didn't do this? Not that I have seen, not that I know personally. They have been very friendly with law enforcement and with the prosecutor. I've seen them interacting with Mr. McLeland and stuff like that. There's clearly an affinity in that sense. They're aligned with the prosecution and the law enforcement. Does that mean they necessarily think Richard Allen is guilty or not? Not as far as I know. I haven't seen anything. Glenn F., you opened my eyes. Well, thank you so much, Glenn. That's a big thing. It's a big thing. So it's been a big responsibility, I felt. I've said a few times, I'm not used to being in the situation where I need to be the fact reporter. I'm used to just watching the trial on TV with everybody else and giving my analysis of it. My thoughts about what I see, as I'm a lawyer, if I'm doing this, here's how I would do that. And here's what I think of that. And this is a really bad ruling. I'm really used to doing a lot of legal research as the trial is going on, getting real familiar with the jurisdiction where the trial is being held and kind of getting to know the ins and outs of the process there. Haven't been able to do that in this case. It's been very, very different. So the fact that me showing up here and being a fact reporter is something that has been helpful to people and that they've trusted. It really does mean a lot to me. So I thank you for that. A Sparky 2, thank you and your mister for taking time out of your life to bringing us this. Well, thank you. I really appreciate you supporting it. It makes it a lot easier for us to do it. This one was important. It was very important. It was worth the commitment. Needed to be seen. Harley Quinzel, they needed a bridge guy. They did indeed. They got a man who was trying to do the right thing, imprisoned him, broke him, set a trial, and they were running out of time. And ta-da, a van appears. Yeah, this is scary for us all. It is scary. It is scary because it just goes to show how easy it is. If police get you in their targets, and they want to come up with stuff that makes you look guilty, it's not that hard. Not that hard. Look at the Google searches. I mean, gosh, anybody who's been really into this case for any length of time, you've got some weird Google searches, there in your history. All that stuff. It's just so easily distorted and built and constructed. And like Mr. Rozzi put, retrofitted. I think that's a good way to explain it. It is. It's taking something in and adding it on to strengthen something after the fact. The van part to me was just inexcusable. I thought he did a great job of bringing that out. They had this information for months, since April of last year, or May of last year. And they only just 2 months before trial thought, oh, hey, maybe we should follow up on this. It's kind of almost like they didn't even care. Kind of almost like it didn't even matter until they realized, oh, shit, they're calling our bluff. It's put up or shut up time. We better go make something out of this van. Margie, do you have any thoughts on who did it, if not RA? It looks too much like Abby was cleaned, dressed, and cradled for there not to be a good reason. I mean, this is why I wanted the Odinist theory in the trial. I wanted that to be fleshed out and vetted. I wanted to be able to hear all of that in the context of a trial with the cross-examination and the opportunity to respond to it and all of that. If it's so ridiculous, then the jury would see that and the jury would penalize the defense for bringing them a ridiculous theory. So I don't see what the downside is unless it's just too on the nose, because it has much more explanatory power for why this crime scene looks the way it does than a crime of opportunity by a guy who just, was gonna do an ordinary run of the mill, have his way with the girls, and decided to kill them instead. It doesn't explain this crime scene and just the weird peculiarities with it. So yeah, I tend to be suspicious of the Odinists and that theory. I don't know specifically who. C. D. Luke. Andrea, if you had to guess tonight, how will the jury decide? If they have a verdict, I'm guessing it's a not guilty verdict. I don't think the jury is going to convict. Just not the impression I've gotten, mainly from how they have responded ever since those videos got played. And they saw. I think there's a lot more to it than that. There's just been so much shady stuff throughout the state's case. I think Mullen really hurts the state's case. I was talking to somebody in the line today about like Mullen and Holman are the ones that were really kind of the worst examples of it, because they did come across as being misleading and deceptive. And you kind of almost got the impression with especially Mullen, the way he handled himself on the stand, that it's almost like you're so accustomed to just expecting your word to be taken as gospel that it's never crossed your mind that people will question what you say, that people have their own minds and can think for themselves and evaluate the evidence independently and are not just going to accept you say this is how it is, therefore that's how it is. It's almost like they're not used to that. Like he couldn't put himself in the shoes of a skeptical person because it just really came off badly. And I think that seriously hurt the state's case. Nicholas Pagano, you are amazing. Recently got into law, and it's horrifying how these prosecutors, judges want so badly to convict someone with so much reasonable doubt. Yeah, I mean, I've said I don't think this case should have been brought. I don't think it should have been brought at all. And, it does. It just calls that motivation into question. Why did you do this? Why? And why then? Why not take the time to build it? It's because there's no there, but it's also because they never followed up to do the things that you would do to build it. Compare the hair from the crime scene to Richard Allen's hair. That one never got mentioned in the closing. That was a piece that was left on the table. To me, that was really significant. Very significant. Like you're not even interested in confirming your theory. If you had so much confidence in your theory, you would do all those things. You would ask the witnesses on the stand, is that guy sitting over there at counsel table the man you saw on the trail? But they're not interested in testing their theory. They wanted like the minimum that they could put together to try to put a case against him and then leave it there and not do the follow-up. So it really does. It calls into question the motivation and the timing for all this. And it doesn't look good. Does not reflect well on them at all. Christy NC, this trial is about three things: a murder, a man, and a miscarriage of justice. Oh, I love that. God, that would have been good. That would have been so good. Oh, boy. Yeah. Yeah. I approve. Let's get you on the staff to help with the drafting the closing arguments. Joanna Newberg. Andrea, what one word would you choose to describe this trial? Sorry, this is going to be a bit of a crude one, but it's shit show. Travesty. I'll go with travesty. Just really all around the basis for it, the way that they handled it, the way they conducted themselves. What came out in spite of their concerted efforts to keep us from being able to see it. Yeah, travesty. Thank you for all your hard work. You're very welcome. Really appreciate your support. PDF photography. Surprised the defendant didn't focus more on the improbability of aliving one girl while the other stood by, change of clothes, etc. Yeah. Yeah, I mean, there's a lot of improbabilities there that they didn't really focus on. You know, the whole thing about the sticks. These are not covering sticks, okay? These are not covering sticks. And there's leaves right there that, you know, in seconds you could scoop some leaves over them and they would be concealed. So the whole put the sticks on them to cover them, very implausible. Abby being so clean, being implausible. But yeah, that's always been a big one for me. That's been a big problem with me for the one-man perpetrator. It just doesn't seem to fit because I can understand, yes, you can hold girls under your control with a firearm while they still think that there may be a way out. You know, if they just comply, they'll get through it, they'll survive. But as soon as you make it clear that may not be on the table, well, your incentive is gone now. You know, and you're busy with the other. How is that not going to give? How is that not going to give one of them an opportunity to escape, to take off, to run, to scream? Help! Really doesn't make sense to me. Tony Elia on YouTube. There is an author, a reporter, 2 lawyers, and a mental health expert examining this trial, all with different views. This jury has some work. Thank you, Andrea. Yeah, I mean, a lot of people with different takes on this. No question about it. No question about it. And the jury is going to come from a lot of different perspectives, a lot of different viewpoints to bring. It really does make me wonder how much that pre-deliberation option that they have may have kind of helped move them forward already. And in a way, you know, one of the things that I've thought about this a lot, you know, and I still like my immediate reaction is like, oh my God, like horror, but that's just because it's different, you know, and everybody is kind of like, I think that's kind of normal. Things are sort of different. You're like, wow, that seems really strange, and strange seems bad, you know, but it's not always bad. In fact, it's often not bad. But one of the things that I did think about with it that I think is actually very much an advantage with that process is that they don't have to wait until the end when everybody's memory has gotten fuzzy about like what happened on day 6, you know, and exactly what did that person say on day 8 now that we're on day 17. Like they get to actually talk about that and process it while it's fresh in their memories. I can see that being a real big advantage to this process. Bird, I'm late, but continue to appreciate your coverage. Well, you made it. You made it in time. Thanks for joining us. MMA Groupie? MMA GPY 9012. Andrea, you have been amazing. Do you think any geofencing data exists for any of the third-party folks that were interviewed early on, Brad, Elvis, KK, etc., that puts any of them near the crime scene? Thank you, and get some sleep. I don't know if they even know, right? Because they insisted they never even examined like Brad Holder's phone. This is kind of more of the trying not to get their questions answered. Things that seem like they would be logical investigative steps to take, or at least pursue. And we know that they're logical because that's what they did with Richard Allen. They looked at his phone, they took down the ID number. But apparently they didn't even look at Brad Holder's phone. So I don't know. I don't know what the geofencing data shows, and it concerns me, because if the geofencing data was incriminating to Mr. Allen, there's no doubt the state would have tried to bring it in. Now, yes, the defense would have been able to move to exclude it, and they probably would have won. The Fifth Circuit has recently held that geofencing data, it's a violation of the Fourth Amendment because it's not particularized. It's a dragnet search. You're just going to the, Google. It's usually Google, and getting all the location data for everybody without any suspicion. Now, that's not a universal rule. It is just one circuit court that's held that, but it's pretty significant that a U.S. federal circuit court has held that. Like, that's very persuasive. But we would have seen that litigation, so we would know. It would not have been the state trying to keep it out. Auto Doctor 911. Why couldn't Brad say that no eyewitness actually said that RA was the person they saw? He could have, I think. Like every other case, do you see Bridge guy in the courtroom? Yeah, I think he could have. He could have pointed that out. He didn't. He didn't. He pointed out that who they described looks nothing like Richard Allen. But yeah, I would have driven that point home. They didn't even ask you. They didn't even ask their witnesses to tell you if the guy that's sitting here in the courtroom that's on trial, the guy that they say for their theory to work, he's got to be the guy they saw, and they didn't even ask him. They didn't even ask them if he's the guy that they saw. Yeah, I would have dug my finger into that one. That's a big hole. Big hole and a big problem. And very consistent with that whole theory that Mr. Rozzi was developing about just what they didn't do. What they didn't do with their investigation. Botanist Gaming, isn't the reason the defense didn't dig into the van because Siegel literally would not let them? Well, she would not let them call the FBI officer to testify specifically to that interview. But it turned out that ultimately it really didn't matter because they were able to get it in through Brad Weber, and then they were able to bring it up in the closing. So it was fine. That ended up being, they were able to work around that ruling. So, I mean, that's what I would have liked them to focus on, because if the state is making this the linchpin of your case, then you want to hammer on it pretty hard. And so the way I see it, there's two angles that it can fail on. There's the angle on Brad Weber was lying and the van was never there. And this is literally something that Mr. Mullen, who has been enormously deceptive throughout this entire process, called him up and had an unrecorded call with him and got him, into the police department the next day, where he volunteered without explanation the information that they were looking for, and that he had investigated it, even though he supposedly didn't know what the topic of the conversation was supposed to be. You can have it fall apart on the van wasn't their end, or you can have it fall apart on the how did he get that information end. And I really would have liked to have seen both of those attacked. Is it impossible that there was stuff about a van in Discovery? Is it impossible that there was stuff about a van and all of this crazy social media madness that was going on that we heard about in the early stages of the case? That Dr. Walla was participating in all of those groups, feeding that stuff to Mr. Allen? Is that so implausible? That she led him down this road? Is that so implausible? Summertime. Why is Richard Allen charged with 4 murders? Can you explain? Thanks. Yeah, so he's charged with 2 different types of murder: felony murder and intentional murder. He can't be convicted of all 4 because they are the same crime. And so if he were convicted of all 4, they would likely have to go in and vacate 2 of those. But they're just different theories. It's basically alternative theories of why he's guilty of the crime. So this is not particularly uncommon to see. Frankie's mom, 143. Could they not have shown what he looked like when he bought beer on the store camera? He didn't throw jacket away, covered in blood, mud. His wife would know. I think the only question would be, because this is so far down the road, They didn't interrogate him because they can't. They can't interrogate him. He's already been charged with a crime. His lawyers are going to be there. They're not going to allow it. If this was a situation where he was confessing and they could interrogate him, that's one of the things they would do. They would try to get more details so that then they can go and follow up and then see, where did you get the beer? Where did you drink it? Where did you throw the cans? And if we were closer in time to the crime, they'd be going to look for that video. They'd maybe even be going and looking in the trash, seeing if they can find the cans. If he threw them in the bushes, go try to find them in the bushes, whatever. Look on his charge card. How'd you pay? Did you pay cash? Did you pay charge card? When did you get the cash? Just try to validate as much of that stuff as they can. But with 5 years down the road, it's almost certain that no video would exist anymore. Security camera video, if they keep it for 30 days, that's good. That's pretty long. Often it's a lot shorter. So I think that was the real issue. And it, in many ways, it worked to the state's advantage here. The fact that so much time had elapsed. So there were ways to validate or invalidate what he said that are simply no longer available because of the passage of time. Nell Wood, fun fact, there are at least 3 ways to take post-mortem body temp without disturbing potential SA evidence. Wonder why they didn't Google that. Yeah, good question. Good question. Yeah, I don't know. I mean, there it seems to me like there was a lot that they could have done to really narrow down the time of death a lot more between, the onset of rigor. The crime scene of investigators should have been able to note that, what stage of rigor are we in? At what point do they come out of rigor? Because these are fairly consistent. I mean, yes, they're broad ranges, but it's enough to help you narrow, a 22-hour period. Same thing with the stomach contents, has the stomach emptied? Same thing with lividity, at the crime scene, document lividity. Has it set? Has it fixed? Just really seems like there was a lot that they could have done that they didn't. Taylor, is there any way this judge will have any consequences for being so biased? Well, the one I keep pointing out is just the political consequences. This has been, a lot of people have been watching this trial. And judges don't often get a lot of scrutiny like this. They don't often get their work watched on this large of a scale. And so I don't know that she was expecting it. She thought that by keeping the cameras out, she could do her thing and there wouldn't really be any check on it. But we ruined her plans. And so now a lot of people have heard how she's conducted herself in this trial. And they may decide to do something about it next time she's up for re-election. That's really the main consequences, Pro-state judges are nothing new. I mean, she has taken it to a extreme. There's no question in my mind about that. But the way they've set up their law here in Indiana, you can't just look at her rulings to say she's biased. So without that, no, nothing through a formal process, I don't think. Serendipity, if the jury is outside of the deliberation room, are they still able to discuss with the alternates? No, they're not supposed to. They're not actually supposed to discuss the case at all now outside of the deliberation room. So once they go back to the hotel, they're not supposed to be talking about it anymore. Wait until they go back in. Theory neutral, great job. My gift, judge only in accordance with an underlying rule you can recast as a universal law without absurdity. Guilty verdicts absent compelling evidence create guilty yet innocent victims, so morally impermissible. Thank you for that. Yes, that is a very Kantian expression. I will say the categorical imperative is what you're applying here, that rule, and it is an important one, and it is one that I hold dear. But it's really the humanity principle that is what draws me to Kant. Treat no man as a means, but only as an end unto himself. That to me is just a very, very important principle. Don't use people. Don't treat people as objects. Everybody has a unique perspective and a unique soul and a unique experience. And That's how we need to engage with each other, to be fully respectful and empathetic, and to really function well, I think, as a community. You've got to have respect for other people's autonomy, their own being, if you're going to live well as a community. So thank you for that. I appreciated that little Kantian perspective. K-Rab, thanks for covering this. Well, thank you for being here with us. I do appreciate it. Cheryl Baber, Andrea, thank you for bringing information and transparency to this trial. I pray the jury can discern the truth. To Abby and Libby's families, I pray the true killers are tried and convicted and you can find peace. Yeah, I really hope that happens. I do. I want these investigators to prove me wrong. When I say they're going to just call this the end of the road, even if Richard Allen is acquitted, I want them to prove me wrong. I just don't know that they will. And it does. It makes me very sad for the families. Rochelle D, can you tell us the difference in the charges that the jury can consider and the penalty that goes with each? So I don't know. I would have to research this. Sentencing rules can get very complex. My gut reaction would be that there's no difference in the sentencing. They're both first degree murder. They're both serious murder charges. Typically, it's just not typical to see a different sentence, a different penalty based on different theories of what's essentially the same crime. So I doubt that there would be a significantly different penalty. But I would need to research this because sentencing gets very complex. A lot of different ways to do it. If this were a trial where I'd been able to sit and have my, devices and stuff like that, I'd have already looked this up. But since I get to use my phone 10 minutes a day, and maybe on the weekends when I'm catching up with my email, all the folks trying to get in touch with me, haven't had the opportunity to do that. L. McCallie girl, do you think it was a mistake not having Kathy testify? If Bridge Guy was my spouse, I would know the clothes, the way he was walking, standing, etc. Thank you so much for your amazing coverage. I don't think so. And the reason why is just because everybody's always going to expect Kathy to be biased anyway. They're going to expect her to be biased, to see the best in him, and that even if he had done it, she wouldn't see it. If she loves him, she wouldn't see it. So I just don't know that there was a really huge upside to be gained by putting her on the stand. And I don't know that Rick would have liked that, seeing her have to go through that, and particularly with cross-examination. The state did not necessarily show the kind of grace to the defense's folks that the defense, by and large, showed to the state's. So I'm not going to say I think that's a mistake, just because I don't think there is anything so material that she would have brought to the case that they couldn't just do without it. But I do understand this perspective, and I think, a lot of people share that. They would have liked to have heard. They would have liked to have heard people say that's not him. It's not him. I mean, they kind of heard it through the phone calls. We know you can't do something like this. We know that's not in you. His parents, his wife. Taylor, I'm no lawyer, but seems RA could win on appeal. NP. Yeah, I agree. I think he's got very strong appeal issues, particularly with the exclusion of the third-party culprit. Boy, Mom, you are overworked and underpaid. Hope this will buy you a beer when it's all over. Thank you. It certainly will. And I will enjoy that very much. Very much. I'm not a huge beer drinker, but I do love a nice, good amber ale every once in a while. I'll drink an IPA, but IPAs can get a little hoppy for me. A little too bitter, a little too much going on there. Something about the West Coast with how they like the brewing. They like to really super hop the beer, and I'm more of a malty beer kind of person. But then, there's always my Pacifico. If you need the good lager, you need a good basic lager. I'm telling you guys, the Pacifico is where it's at. Very good stuff. Bridget Wainwright, if it's possibly plugged in at 5:30, you must vote not guilty. Yeah, great argument. Great summary. Exactly. If you can infer multiple things from the evidence, you got to adopt the one that supports him. And here it is right here in the data saying there's a headphone plugged in and unplugged. The state wants you to think it's dirt. They haven't proved that. Their own file, their own timeline that their expert created shows that it's a headphone. You have to draw that in his favor. It's not consistent with the state's theory. You must acquit him. I do like that. Sharon LeBerthan, this one is for all the hubbies named Jeff who are out looking out for their wives. Yeah, that's very sweet of you. He's a great husband. Really appreciate having him here. Donna Brack, Andrea, you would be great in a federal position of your dreams. Would I? Would I? I mean, I do. I appreciate this compliment because it's a big one, and I do appreciate that. It's never been my career path. It's never. I've always been kind of a lone wolf. I've always been fairly independent in my work and my goals and stuff like that. And it's not that I don't think I'm like a bad team player or anything. Maybe people on teams with me would disagree, but it's just not my scene. It's just not my scene. There's too much. I mean, you know how it is with jobs. Is kind of the stuff that they talked about in this trial with Richard Allen. He would get into the management. He talked about it in his interrogation. He would get up into the management, and then it's all just a bunch of hassle, and they don't care about the customers and stuff like that. When you do independent work for yourself, you just have so much freedom to decide what matters, how you're going to do it, what your quality standards are. I have very high quality standards. It would drive me nuts to be in a setting where that wasn't shared. It would drive me nuts to be in a position where I'm being constrained in ways that I don't agree with, that don't seem right to me, that don't make sense, that I think are wrong, that I think are counterproductive. And that's just what the federal bureaucracy does. So I do very much appreciate that compliment, but I will admit, I don't know that the federal position is for me. I mean, I could have pursued that. I could have pursued AUSA, all that stuff. It just has never appealed to me. Barb Funk, thank you so much for your coverage. It has taken my blinders off and made me see the importance of a good defense and a fair legal system. If anything can be accomplished through all of this, it's pushing back against this narrative that defense lawyers are just shady and always trying to get guilty people off. These guys have worked so hard. They have worked against insurmountable odds. They have endured so much hardship. And they've continued to fight for it. They've just raised the bar so far beyond the very minimal standards that the system has for appointed lawyers. They've gone so far above and beyond. You gave us a year of law school. This is haunting. I appreciate all your work, Andrea, and knowledge. Thank you so much for that. It's really been my goal with this channel the whole time, is to just kind of help people see things through the lens of how the lawyers see them. I think you get a better understanding of the system because it's lawyers that built the system. And I know it can often be pretty opaque to people that aren't dealing with it in and out every day. Melissa Bond, just seen crime scene photo. This is deeper than RA. Crime scene photo is very hard to explain as a crime of opportunity. Roberta Alton, Andrea, do you think Richard is guilty? I do not. I don't think he did it. After all of this evidence has been in, I don't think he did it. Run the world. Thanks, Andrea. You're an extremely cool gal with a heart of gold. Wish you were my neighbor. Well, thank you so much. We can be like sort of neighbors, on here. We'll see each other from time to time, have our little chat over the fence. Lana, love the flowers behind you. Hoping locals are spoiling you. You deserve it. You're doing a great thing. The locals really are spoiling me because they're the ones who have stepped up to do the line sitting. I mean, a lot of people have, don't get me wrong. People have come from all over. Pretty sure the girl that's out there in the line right now came from Chicago. Somebody else has come from over near Boston. Cookie was here in the chat. So people have come from far and wide. But a lot of the local people stepped up when we were in the middle of all this chaos and helped make sure, like, okay, we need to line up again at lunch and we need to line up again at the end of the day and like all this stuff. It was local people here that stepped up and made that happen. And I'm so grateful for that. I really am. It meant a lot to me because I know that this crime and this trial and this case meant a lot to this community. It had a huge impact. And so the fact that they value the way that I'm telling you about it, that really does mean a lot to me. That's a great review right there. Beverly Bigglesworth with a super chat. Thanks so much for that. T down 43. If the gun was racked on the bridge, how was it found by the bodies? I know this has just never been explained. If it was racked, why would it even be racked by the bodies in the first place? I don't understand. I don't understand. No bullet up there, but the bullet is down below. There's no explanation. It's just one of many things that is unanswered. Lisa Shelton, 1 hour and 20 minutes from you. Everyone can stop donating to the flower fund. I bought her some, lol, and I got either really, really good perns. I don't know what that is. I did buy flowers from the flower fund. So they are kind of over here. You can't really see them very well, but it is nice to have something on that counter. I got this lovely fall bouquet that's like orange chrysanthemums and yellow roses and very, very beautiful bouquet. So thank you all who contributed to the flower fund. Melissa Bond, I have seen the crime scene pictures. Please be careful. This is being covered up. This is deeper than RA. I understand why the last judge stood down. I am being very careful. So definitely watching my back, taking precautions. Nordic Phoenix, as an advocate for mental illness policy and care reform and mom of a son who suffers serious mental illness due to brain injury, this trial haunts me. The blatant abuse and manipulation of Richard Allen's mental health is criminal. It is. It's abusive. And it should never happen. Beat Woot Banana, where can I find info on the geofence data? Everything that we know about the geofence data came out in the pretrial litigation. I can't remember if this is one that they denied without a hearing or if they did have a hearing on it. I think they may have had a hearing on this one. But so there is motion. You can read the motions in the court record. I always recommend All Eyes on Delphi has the great compilation of all the court documents. Sleuthy Goosey also, if you can get her Delphi spreadsheet, she's got a good compilation of the court documents. So a couple different places where you can find those. Otherwise, these trials haven't been public. And so like the hearings, the pretrial hearings and stuff. And so, it's a little bit hard to get access to that. Some of the folks who were able to find some of the transcripts have been able to reproduce some of that for us, but I don't think that included the metadata. I'm just not entirely sure because I still haven't been able to go and review that. Not enough hours in the day right now. Gloria Smets with the super chat. Thank you so much for that. Litigation Examiner. The phone call played today between Richard and Alan and Kathy, whom you initially reported was presented as RA and his mother. You questioned this at the time. Once a verdict is reached, could this matter? I think the likely explanation is just I was probably not right. I don't know that I don't know that this was the 431 wasn't the one that I thought was his mom. It was a different one later on. And I don't think, I would have to go back and look at my notes. It was just a different one that sounded more, because we had heard one of the calls to his mom already. And so just the voice sounded more like his mom than like Kathy. But I'm not 100% on that. That was just kind of me guessing. Like, did they get that wrong? Is this his mom or is this Kathy? But it was one of the later phone calls. It wasn't this early phone call. So I don't know ultimately if any of that is going to matter as far as these details. I think that the real thing that's going to matter the most is just, does the jury believe that these are false confessions or not? Are these false memories? Are these things that he's creating in his mind because he's stuck in solitary and has nothing else to think about but sink into his mental illness and his depression and perseverate over his guilt and responsibility and feeling like he's let his family down and like he doesn't deserve to be loved, and spin that up into, maybe he really did do it. I think that's what's really going to matter out of these phone calls. Harley Quinzel, had RA had a speedy trial, he would be free now. Yeah, it's true. It's true. Back in May. I was ready to come here in May too, by the way, but that didn't happen. T-Money with a super sticker. Thanks so much for that. Beverly Bigglesworth, if RA goes to retrial, I hope that his team can crowdfund the best experts available. Thanks to those of you sharing the truth. Yeah, I do hope that it would be easier to get the word out, just to raise the profile. There's been so many eyes on this case now because of the trial. And a lot of people very, very concerned about this process and the fairness of it. So I would love to see that. Just a good war chest. If the judge isn't going to step up and be fair, give him fair access to be able to contest the state's theory of the case, then yeah, I'd certainly contribute to something like that. Melissa Hill, is it at all possible that they will let Alan out of custody if there is a hung jury because of the torture he's already been put through? I would seriously doubt it. It's not the norm. They can reconsider conditions of release, but it's not the norm because from their perspective, nothing has changed. Nothing has changed. He's still charged. He's still, the same flight risk or risk of, inflicting harm on the community or whatever the initial justification was for where the bail was set. So they could ask, but, this is Judge Goal. So I would expect that would be largely like talking to a wall. Lee Bierbeck with a super chat. Thank you so much for that. Angie, can you compare Koberger's versus Allen's housing situation? Yeah, I mean, as far as I know, Mr. Koberger is also in a one-man cell, but he's in a one-man cell kind of like they described with Cass County, where there's at least some kind of collateral contact with people. He does get to have regular visitation. He does get to have rec time. He gets to be on the phone. And there's more, more for him to be able to do and access where he is. It's still not, it's jail. That is a point, Gallipo made the point. Well, it's prison. I mean, it is. It's never going to be fun, but it's not going to be this tight, confined with nothing to do, being stared at all the time, monitored constantly, kind of scenario that it was for Richard Allen in Westville. Megan L., would Odinism be grounds for FBI to reinvestigate? Well, this is the only possible hook that I could see. If they have identified any, white nationalist terrorist groups in this area that have, some kind of connection with Odinism, that's a potential link for the FBI to be looking into it. Because a lot of these organizations, they've made a point a couple of years ago coming out and saying this is like one of the biggest threats to American security, is the white nationalist terrorists. And so they put a lot of these groups on watch lists and stuff like that. If they can make that connection, or if any of the individuals involved have those kinds of connections, then potentially they could. Pretty much the only way I see for the FBI to get back involved. That said, FBI already knew about the Odinism theory. And when they were asked to leave, they said, okay. I mean, as far as we know, they said, okay. And they left, and they didn't. So I don't know if there's like anything new at this point that would change that status. AKA Radar, I'm confused about vertical wounds. Sorry. May I ask about? Okay, if not. Confused if all were same size or possibly if they were made by a multi-blade weapon. Was Abby similar size wound? Thank you so much, Andrea. Our eyes. Yeah, so Abby's wound was about like this. And it was horizontal. Libby's wounds were about like this. It looked like 3, but he testified that one of them was actually 2 separate cuts. So they were very, very different wounds. The length of them seemed pretty similar, like not a big discrepancy between them, which is very dissimilar in terms of how they would have been inflicted, and what would have needed to be done to inflict them. The side wound is, I think, what you would just always expect with that kind of injury, because that's just a natural motion for a blade. This motion seems unnatural, and because it's the head has to be back. So it does suggest to me, her head may have been held back. It's not pleasant stuff to think about at all. But no, it didn't look like it was a multi-blade tool, because it wasn't like uniform. It wasn't evenly spaced. It wasn't uniform wounds. It was at least 3 and as many as 5 separate like swipes with the blade. Glorious Mess, similar UK case, worth look at. Soham murderers. I will write it down. Add it to my list. I'm going to have so much to do on the plane home. It's great. Download all kinds of stuff. You guys are giving me all kinds of brain food. I just love it. Gen X girl lawyer. Great work, Angela. Well, thank you. Thank you. I see you corrected it. Great work, Andrea. Thank you very much. Appreciate it. Appreciate your support. Litigation examiner, what was Abby wearing in the video? So when you first see the video where she's walking, she's wearing her jeans, her pink shirt, and the zip-up sweatshirt is over. It's over her. It's not zipped up, so you can see the pink. When you see her run by in that portion of the video, you don't see the gray sweatshirt part. You just see the red shirt and the pants. So she's not wearing the Delphi sweatshirt at that point. That's very clear. She's wearing a gray zip-up hoodie that is unzipped. AJ Charles, Penn Gems pens made right here in Texas, female-owned, Texas native, and U.S. Air Force veteran. So if you want to support a strong, amazing female, and the pins are amazing and can be refilled with gel ink. Penn Gems. Writing it down. I'll check it out. My eyes have been open. There's like a whole world of good pins out there. All this time I've been such a Philistine with my my Uniball Vision Elites, which I do still love. I still love you, Uniball. You're still a wonderful pen. But boy, I do like that Sharpie gel. Massage Girl, the Google search "We Shall Not Die Now" was for a movie released in 2019 about the Holocaust. Just saying, their Google search evidence is dumb. Yeah, I agree. It's really dumb. It's really dumb. And it's appropriate to call them out for it. Googling the Delphi murders after the murders in Delphi, every person in town did that. It's just such an odd thing to try to present as incriminating. It seems very unself-aware. The crypto tax lawyer, get your super chat in by 10 p.m. Eastern. Our girl needs some sleep. Yes, thank you for that. We are past the deadline. We're coming up close to 11 o'clock. And that was really my goal, is just to be able to Check out well before midnight. Get some rest. Odin's daughter. I hope the jury sees the truth. We need justice for Abby, Libby, and now Richard Allen. Whoever did this needs to be off the street. I agree. I mean, if there's one thing that stands out to me about this crime and what it looks like in terms of who did it, it's somebody, it's a psychopath. Somebody with enormous, complete disregard for human life and well-being. Don't get that from Richard Allen, but it's not a person you want to run into in a dark alley. This person needs to be caught. Summertime. If jury is hung, can the judge decide in Indiana called an Allen charge or something? I hope it can't be goal. Thank you again for everything. No, the judge never gets to decide guilt or innocence. Unless you stipulate that you waive your right to a jury trial, but the right to the jury trial is in the Constitution. And so she can't supersede that. The Allen charge was something, I believe that was from the Karen Reed case, and that's what they call the dynamite charge. It just basically is like the final instruction that you give the jury that tells them, keep trying, one last try, keep giving it your best effort, but don't compromise your sincerely held beliefs. Just sort of encourages them to, try to work past the deadlock. So no worries that she would be in a position to decide guilt or innocence here. Mama She 13 with a super sticker. Thank you so much for that. Auto Doctor 911. Please look at Texas versus Robert Springsteen and Texas versus M. Scott. Interviewed initially 1991, brought in and readed to 8 years later. Very similar, except prison solitary. Texas versus Robert Springsteen. Texas versus M. Scott. 1991. I'll check those out. See if I can find them. Interrogation and read. Thank you for that. I will definitely take a look. Clinton Hall. Curious why the defense skipped the site visit. It changed my perception and seems crucial for the jury. Also, why didn't they conduct their own height analysis when the prosecution didn't? I doubt they had the resources to be able to do it. That's really my main guess. I bet they would have loved to have done more with the cell phone forensics that they just couldn't do because she wouldn't give them the money for it. And so they were able to fundraise some, but experts cost a lot. They cost a lot of money. So to get something that would meet the standards that you'd need to establish to have it validated and authenticated and able to be presented in court, it's going to be expensive. And I would be willing to bet they just didn't have the resources for it. As far as why they skipped the site visit, I don't know. My initial thought was because it's a different time of year and the conditions are different than they would have been in February. And we can kind of see that just from the photos from the crime scene. It's different now because a couple of weeks now have passed and more of the leaves have fallen off of the tree. And so in that sense, there's probably more visibility closer to like it was in February than there was when I went, 4 weeks ago now. But there was also big difference with the volume of the flow in the creek. It was very low when I went. I remember looking at the creek and thinking I'd be shocked if anybody canoes in this. It's very, very shallow. That's not the condition it was in February from the photos that we've seen. It was like waist high at least. So it could just potentially create a misleading impression about, how easy it was to get across the river, stuff like that. That's really the main thing I can think of. Just they didn't, after thinking about it, think that the jury would really get a fair impression of the circumstances out there. Would have been nice for them to have seen the south end of the bridge too. And of course you can't, not that I would be encouraging taking the jury across that rickety thing, unless I guess they really wanted to. I sure wouldn't. But the south end where it's private property, not sure that they really could. It would be trespassing. Technically it's trespassing. But that does seem like an important part of the story of the crime to understand. I think Mr. Rozzi did a good job of just addressing that from the data. The fact that, look, they only went down 2 stories, but it's 65 feet. You're saying they went from the top of the bridge down to having to swim across the water. The elevation doesn't match, but it matches the road a lot better. It'd be nice to see that. It'd also be nice to see this embankment off the side of the road. You know, how steep is that? Are there places to hide under there? How far is it to Brad Weber's house? Always would be nice to see stuff like that. Kate Tucker, why did law enforcement never do a walkthrough of the crime scene with Richard Allen after he made informal confessions to determine the veracity of his confession? Is a formal guilt plea required before such things occur? Those things rarely occur anyway, honestly. It might happen like before charging, or yes, like you're saying, if there's a plea deal. That's happened in cases like the Green River Killer is a really notorious example. They took the death penalty off the table because he was willing to like take them places and provide, you know, information about things that had been unsolved, confess to some of the crimes they hadn't been able to link to him and things like that. So it's not completely unheard of, but it's also just not very common. And so if it's not a situation like that, I think where they're continuing to look for things like that would be bringing other people closure. At this point, because, you know, he's confessing, he's got a lawyer. They're never going to allow him to do that. The police would have to go through the lawyers, and they're going to say, no, absolutely not, because these are false confessions. So that's the main reason why. Once he has the lawyers, they are going to shield him from the cops continuing to try to get statements from him. Marcelo, now that trial is done, I have one question. How do you think Jeff is feeling right now? 1, happy his wife is back. 2, sad his wife is coming back. I'd bet second. Lol. Nah, we were just chit-chatting about it today. When am I going to get home? My original plane ticket is for the 20th. That's still almost 2 weeks away. So looks like I'm going to be able to get home earlier. And I think he'll be happy about that. Let's be realish. 1, did the defense ever bring up the saw, cut wood in this trial? No, they did not. I don't know that they would have had, I believe that information came from one of their experts that they brought in at the Odinism hearings. And so they could have brought that person in just for the sole purpose of presenting that the wood, you know, had saw cuts on it, because I don't think it was something that anybody at the lab caught. But ultimately, it's just a question of priorities. You know, when all is said and done, is that going to be the most important detail to spend the time and the money and everything on? You know, maybe not. 2, did Nick address the Brad Weber angle in rebuttal? No, not really. I mean, not any more than kind of what we described. And it's just the van confirms what he said. The van, you know, only the killer would know, but they really didn't address the problems with Brad Weber's testimony. So, nope, didn't respond to that. Aries 414, you mentioned a roundtable with Lawyer Lee and Bob. Do you have any idea where they stand on the verdict? Have they stated their opinions? You may not feel comfortable saying, but I'm so curious. Well, we're all lawyers, and so we're all like, always it depends, and kind of wishy-washy about making predictions and stuff like that. I don't know if they have specific opinions on what they think the verdict is going to be. I believe they both don't think the state has met its burden of proof, but I don't want to put words in their mouth. You know, I would let them speak for themselves. So predictions, though, are always a challenge. Litigation examiner, if the girls could see a creepy guy coming and have time to get phone out and turn camera on, why would Abby be on bridge with bridge guy? I mean, I just thought it was such a blow when the jury asked that question about Why don't we think somebody was at that end of the bridge, the south end of the bridge, and walked past them and then turned around and came back? Because to me, that seems like such a logical explanation for why it would get you attention and get you to start filming. That is creepy. That is sus. That is behavior that's threatening. Some guy just randomly walking on the bridge behind you in an area where people walk. To me, that just doesn't seem like something that's going to catch your attention and in and of itself, make you scared. Seems like it would make a lot more sense. Somebody passed you and then turns back. Yeah, that's going to creep me out. I mean, it is a very rickety bridge. If you're barely walking on it, you're probably not going to want to run on it. It does seem though, like I think maybe what you're getting at, that first photo of Abby on the bridge when she's out, they're out at the platform. I think the photo is being taken from the platform. So they're quite a ways out, and you can see back to the beginning, and there's nobody on the bridge behind them. And so for Bridge Guy to have gotten where he is, I don't know, 10, 20, 30 feet behind, it's very hard to gauge from the film. They either would have had to been like really dawdling as they're crossing, at which, and then it's like, well, at what point did you notice him? And then at what point did you decide he was creepy and needed to film him? Or he was like really booking it across the bridge a lot faster than they were. But it's not what you saw in the video. It's just walking at a pretty normal pace across the bridge. So yeah, just some more food for thought there. Marie-Pierre Robillard, still can't wrap my head around the judge not allowing the defense to argue other plausible theories regarding who might have done this. Yeah. Doesn't really seem very fair, does it? You have a constitutional right to defend yourself, but you can't actually say somebody else did the crime. Seems a bit illegitimate. Clinton Hall. Oh, this is your same question. You repeated it. I am interested to know how it changed your perception. So when I see you tomorrow, I'll probably ask. Interested in your take on it. Ashley Lauren, 10 p.m. We want you to sleep, lady. I will very soon. Very soon. We're getting close to the end here. Gina Marie Tomeworm, my sister-in-law is a psychiatric nurse. She said Richard Allen could have been having a depressive episode with psychotic symptoms, which would be treated different. Haldol should be used for long-term psychosis like schizophrenia. That's interesting. I had like 5 minutes at one point to like look at some stuff on Google. I was looking at what are the approved treatments for major depressive disorder with psychosis, because I was curious if Haldol was in any of them. Apparently the deal, this is a difficult condition to treat. And so they tried different combinations of antidepressants and antipsychotics. And so there have been a variety of very specific combinations that have been studied, and they've gotten results about them working or not. Didn't see a Prozac Haldol combination, that's for sure. That's for sure. Amaranta Arcadia Castilla Gomez is a new member. Welcome. Bienvenido on the channel. T Money is a YouTube member. Welcome. Amanda Floranten is a new member. Welcome to the channel. Thanks so much for joining. Kathy Belbin has got a super sticker. Thanks so much for sharing that. And Resist Decline is going to close out the evening for us with a super sticker. Guys, I'm really just continue to be so grateful for all of you, continuing to show up, continuing to support what we're doing, being open. I can't tell you how much it gives me hope in the world that so many people are open to seeing things in a new way, to having their eyes opened, to having their perspectives altered. My perspective on this case has changed a lot since I first got here. My perspective on the handling of the case has changed a lot. I mean, I kind of, I kind of knew it was bad, but just the scope was not what I had in mind when I thought I was going to be coming over here to try this. So I appreciate having you all around here to share thoughts, share ideas. It's a great community we have here. I really enjoy it. So many smart people with great insights. I feel very lucky to have that here. And I appreciate all of you just sharing this experience, this journey, bringing the eyes on this case that just so badly needs it. So badly needs it. This should not happen. And the more people that see it, the less likely it will, because the more people that see it, the more people will be outraged by what they're seeing. So I appreciate all of you joining me for this whole endeavor, this whole undertaking. It's been a wild ride, and we are very close to the end of the road. So we'll see what we get tomorrow. I'll be going back down to the courthouse for the verdict watch, and we'll see what we get. But as far as the substance of the case, it's not going to be a whole lot more to report on until we get a decision one way or another, or don't. So I'll plan on checking back in as soon as we got more information, as soon as we know what's going to happen. And I'll talk about what it all means. Thank you guys again. So grateful. The mods, the line sitters, my husband, all of you who have supported this whole endeavor. Very grateful. With that, I'm going to get some sleep at the early hour of 11 o'clock. What a luxury. And I will plan on seeing you guys again soon.